Comments? We can vote on 12 or 14.
Right.
Did anybody else have comments on 12 or 14?
All right, so I move that the minutes of the March 12 meeting be approved as presented.
Second?
All in favor?
Aye. And
Opposed? Ayes have it.
Ayes have it. And then I move that the minutes of the March 14 meeting be approved as presented.
Second.
All in favor?
Aye.
And then we'll,
Ayes have it.
ayes have it. And then we'll have the 21, 25, and 28 next meeting. There may be a couple of others that we sprinkle in there too, and then we'll be up to date.
Great. Okay, we usually go to the master schedule, but can we put up the master schedule on the screen, though? I do want to have the, Elaine, can you have the main page of the screen of the master schedule up when we're having these next two conversations? Oh, you got it? Oh, sorry, I thought. We're going to hold the master schedule conversation until we have the next two topics, because they bear on the schedule. So we will next call on Director Wells for an update on the Investigations and Enforcement Bureau.
Good morning.
Good morning.
Good morning.
I am pleased to report all 11 of the investigations are well underway. I'm generally pleased with the progress and the pace of the investigations. The Massachusetts State Police, along with the consultants, are extremely busy, and there is a lot of work that's been going on right now. As I've reported previously, the 4 slots investigations have been expedited. As of yesterday, the expectation was that 3 of the 4 could probably be finished by the end of this month, the end of April, and the 4th may go into the 1st through the 3rd week of May. So that would be my best estimate right now.
Okay, I just want to check in there. So we have, by the end of April, Commissioner Zuniga, can you look at this?
Yep.
It's April 20, end of April was what we had put on the schedule, right?
The original schedule.
Right here. When
Right.
the investigations,
Right.
for the category 2, this is the category 2
Right, okay.
line. We're on track for 4:30 as.
Yeah, I mean, that's pushing it. I'll put that out there, but they're really working hard, and they really have prioritized these investigations, so that they've done a good job, and they're moving on those. You know, with a caveat, one entity is a privately held company, and there are particular sensitivities with a privately held company, and we're taking those into consideration with respect to the investigation with their corporate structure. At least one of the slots applicants, they recently made a change to their structure, which we expect that'll necessitate the addition of another qualifier. That means a whole other set of forms. We've got to go through the process with that potential individual again. I'm going to watch that. I've just received information yesterday about that, so I have to watch that. So this is a fluid process. It's somewhat of a moving target, so I want to make sure the commission is aware of that. So these, as investigations go, you can, lay your plans out, but if we get something that's concerning, we'll follow that path and, see where that leads. But right now, as of today, that is my best estimate on the expectation and the timeline.
Director Wells, when you talk about completion of the investigation, I believe you're referring to all of the information, all of the interviews will be complete, and then will you need additional time to prepare a report and a presentation to the commission?
Yes, that is my expectation. That would be the best thing for the commission, and I think just putting together that information in a way that's sort of puts all of the 4 applicants on sort of the same footing, it's apples to apples. You're explaining it in the same way, and being able for the commission to have a good comparison. I will be evaluating all the information from the consultants and the state police and presenting that to the commission for their consideration so they can vote. So I am in the process of also looking, at other jurisdictions, see how they present the information so we can do it in the most comprehensive and understandable manner for the commission.
So you anticipate that taking,
It
you would need a couple of weeks, I would suspect, to put that
potentially, yes.
together.
I mean, it depends on what the result is. Obviously, if the information comes back that everything looks good for all 4 qualifiers, that's a much easier presentation to the commission. However, if there are potential issues that I think need to be addressed and I have certain concerns, that I think will need some time to flush out, because I have to present where, what's the basis for that concern. And, I've said previously, if everything works out well, there's not much to say. But if there are issues with those 4, then, or any of those 4, then that will take some more time. As of, right now, it's impossible to say for sure, but I just want the commission to be aware of that beforehand.
Okay, so I just want to look at this. On our present plan,
Yep.
we were anticipating approving the Category 2 applications, background checks, by the end of April. And at
Yep.
this stage of the game, it looks like we will have 3,
Not
Not
approving. Not
sorry,
approving.
making the recommendations to us, sorry, completing the background checks.
Completing the background check.
Completing
Well,
Completing the
right, and then there's the presentation part, and
Right,
so.
yeah, sorry. But thank you for correcting me, that's
Yes.
right. Completing the background checks, which is what we're talking about.
Correct.
By the end of April, and it looks at this stage of the game like at least 3 of the 4 will be okay.
That's my guess.
Then the 4th may go over 2 or 3 weeks into May.
That's right.
Okay, and then we have given ourselves this almost a 2-month hearing period in case there are appeals to the
Right.
IEB decision.
Correct.
And we may or may not have that. But so fundamentally, at this point, this is now going to go to our eventual conversation on the master schedule.
Mm-hmm.
It looks to me like, for the most part, relative to Category 2, we're okay in terms of our regular schedule. Whether we-
Mr. Chair, other than, if we're talking about suitability,
Right,
that determination could not be made until report preparation and presentations, and then a vote.
right.
So that does push us back a couple of weeks.
Well, that's out here.
Yes.
Determine
Well,
suitability was.
hearing,
But the MGC
Hearings.
review?
Determine suitability on our present schedule doesn't happen until July 25th.
That's correct. Well-
And we've been talking about, can we move everything back a little bit in order to maybe award the license sooner than December? And we'll talk about that further later on when we hear more stuff, but, so the only thing that was scheduled to happen, I misspoke originally, the only thing that was scheduled to happen by the end of April was the end of the background checks. The
Correct.
decision by the commission was not until the end of July.
That's correct.
Okay. See, right this
and the
one,
hearing period,
right here.
correct, but those would be for
Of
hearings.
appeals once
of
the decision is
appeals once the
made.
decision is made.
So
That-
for-
But can we back up for a second? The decision by whom?
My understanding is that I would, present a recommendation to the commission, but it's the commission would vote, and it's their, vote. And then after that review, then there is a potential hearing, or is that
Appeal
backwards?
to us from our decision?
Oh, no, so if, right,
The regulatory structure, if my memory serves me, is that the IEB makes the suitability determination
and not a recommendation to the
and
board,
not a
okay.
recommendation. And then there's the right to appeal to us from that suitability determination.
Okay, so then I would need to have that done, but are you saying by that calendar, by the 1st of May?
Well, no, the MGC, my recollection
Yep,
is that the MGC review period was for the IEB to process the results
okay.
of
Yes.
okay.
the
that's helpful.
investigation.
Okay.
Make a determination, notify the applicants of the IEB determination. And then the hearings period was to take account of the appeals to the commission by a disappointed applicant, if there happens to be a disappointed applicant.
Okay.
And
So
then
if-
we
okay.
decide that appeal and move on.
So if all 4, the IEB recommended, say on 5/29, that they were all suitable,
Right.
we're done on that date. There's
Right.
no need to go before the commission, or does the commission have to approve that recommendation?
My recollection is that that's an IEB
Okay.
determination.
Okay.
Right. Determine suitability is after we find out whether there are appeals or not.
Okay.
If there are not, then you'll make your recommendations to us and we will decide. But if there are appeals
All right.
on your decision,
Okay,
right,
okay.
I have to, that's a technical point, Mr. Chairman.
Yeah.
It may, my recollection, and I should have read these regs again last night, but my recollection is that if the IEB concludes that they are qualified, the IEB reports to us, and that's it.
Okay,
That we get involved if there's an appeal from a negative determination, and then we have something to do.
That's my recollection as well.
Okay.
And perhaps the title of the activity that begins on, at least as per this schedule, that begins on May 1st, really should be the IEB report
review.
formulation.
Right.
Okay.
Not it confuses because it implies, at least as it's written here, that it's the commission the one reviewing.
okay.
Is that the regulation?
No, I'm just talking technically about.
Oh, you're looking at the
Right.
schedule.
Yeah.
this
Just-
language
just
right
that-
here.
Just
is
that
misleading.
title is misleading slightly.
That's really
Okay.
IEB determination.
It's really the
Okay, so
IEB
that-
determination.
Right.
All right.
It's worth just double checking this and.
No, it is. That's
Yeah,
right.
and we should, and I think we probably ought to have,
All right.
we ought to have this stepped out.
Okay, and
Um,
I can work with legal and just make sure we're
Right.
all squared away on the regs, but,
Right.
I mean, either way works,
Yeah.
for me, that
Well,
we're
it's-
making a recommendation
It
one
makes
way or
a
the other
big
if it gets
difference in
appealed. But
in
it's
how
the
quickly
timeline,
we
yeah.
Yes,
can
it
do
does.
this if there's no negative assessments.
Right,
Right.
right. And, but I'm not sure that I necessarily agree with your point, that if if the IEB recommends approval, that's end of it. I thought,
I would have to look at the reg.
okay,
again.
because the question is whether the commission
Right.
will and need to approve approvals as well as approve
Okay.
disapprovals.
Okay,
So, but let's clarify that for everybody's
Okay.
purposes. But in the overview, I think we know what we're talking about, and I think for the time being, what we're saying is apropos of Category 2 licenses, we're doing fine, schedule-wise,
I think we're in good shape.
for the time being.
I do.
And as to whether we can move the dates forward or not,
Yes.
there's a big factor that's beyond our control.
Correct.
Which is the hearing possibility.
Correct.
We'll likely get into this on line item 5, but at least one of the scenarios that we presented, that we will talk about later, had that date of April 30th moved up. It doesn't sound like what you're saying, Director, that that's much of a possibility
No.
right now.
No, I would not say that. If we have time savings, it's between that 5/1 date and this 7/25 date.
Right.
And that's a reasonable expectation, but until we complete the
Right.
investigation, we won't know
Yeah.
that for sure.
That's, even for hearings, that's a lot of time. It's 3 months that we put in there for cushions, so.
But as Commissioner Cameron mentioned, if there is an issue and that information needs to be presented to the commission, if there's a negative finding, her point is very important, that there needs to be time for preparation of that. It's almost like putting a case on for a jury. So
Yeah.
that's significant,
Yeah.
that will take time.
Right.
Because that's a different process.
Okay.
And you'll need to know that information.
Okay.
Okay?
Well, that's good, but, whoever came up with this original chart did a pretty good job.
Yes.
Because that gives us the right amount of time.
Yes.
So, but let's
Thank
do
you.
make
That was
sure.
us.
That was us.
Yeah.
You're looking at them.
Yeah,
Right.
good job. Thank you.
Commissioner Zuniga and Commissioner McHugh, nice job.
No.
We-
I liked it.
We're collectively, with the help of our consultants as well, so we cannot take all the credit.
No, but that's good. But let's be specific, that we should write out the process, exactly what the process is between IEB determination and approval of applicants, just so we know exactly
Right.
what these steps are we've just been talking about.
Right.
Okay.
Okay, sounds great. And then as to the other 7 applicants for Category 1 licenses, I think the expectation was, to the consultants and the Massachusetts State Police that, this would probably be about a 6-month investigation time period. I just want to point out that 6 months is a compacted time frame for these types of investigations.
Let me just interrupt you, make sure everybody knows this. We're now talking about Category 2.
Category
Sorry,
1.
Category 1, and the background checks on this schedule, getting to the same point, which is the IEB determinations, was approximately 6 months from January 15th on the schedule here is the end of June,
Well,
6/28.
yeah, and I had, 6 months from, really, if they came in on January 15th, 6 months is July 15th.
Right,
And,
right.
there's a little time with the paperwork and getting everything to
no.
them. I think a fair assessment of a 6-month time period for them to start working really is the beginning of August.
Okay.
Now, these are complex investigations with both domestic and international issues. Until, we received the table of organization from all of these companies, we didn't know how far they went. Now, there are significant international components to a number of these investigations, and that will take some time. Now, generally, I found that the applicants have been, very cooperative in complying with supplemental document requests. What happens is the applicants fill out their initial forms. They're reviewed by the consultants, the, state police, all the investigators on the individual applicant. And then a supplemental document request has gone out. So based on what they've been given, they ask for additional information based on what the structure is of their company, potential issues. They do open source checks on all these entities and check them, and then they will ask for supplemental documents to come in. Now, for example, we will give supplemental document requests, indicate, there's 50, 60, 70 items, and give them 15 days to respond.
Like what, for example? What would be?
Oh, it can vary. They may, information on litigation, may want information from bank records, they may want more information on an incident that occurred within their company, they may want minutes from some kind of, on an issue that they have, on their company internally. It runs the gamut, and there may be information they have right in-house, but there may be information they're needing from third parties as well. And there may be information from individual qualifiers as well, not just the company, but the individual qualifiers. As you know, we're investigating approximately 300 individual qualifiers, some of whom have been investigated before and they know the routine and they can get their information pretty quickly. Some have not been investigated before, and that is somewhat, somewhat difficult for them because there's a lot of information, if they're, information from their curriculum vitae or from their, from their bank records or from litigation they may have had. So that becomes a little more difficult if someone's never been through the process before collecting that information. So what we're finding is that generally the applicants are in good faith trying to get us the information, but if we give them a deadline, sometimes, they can only give 60% of the information and say, look, we've got you this piece, we're still working on the rest. And that's what we're finding is there's a back and forth with the applicants where they're giving it to us as they can, somewhat on a rolling basis. Not necessarily, some may, but not necessarily giving them a deadline and then they hand us, a thumb drive with all the information all ready to go on that deadline. So, we're working with them. It's an ongoing process, but it does take some time and things can be complicated. As I mentioned, third-party information can be a little difficult if you're looking for tax records, if you're looking for, information from other third parties, from banks. They are reliant on the banks and their time frame. Issues regarding international requests. For example, we were dealing with the Macau Data Privacy Act. There's some information that, if we're looking from Macau, they can't send it out because it's against the law for them to send the information out. We need to send someone over to Macau to view that in that jurisdiction. They can't release the information. So, just continue to work with the applicants.
How many of the 7 have international presence?
That's hard to say. That there's because there's companies that have international casinos. So, for example, Wynn and MGM have casinos in Macau, for example.
Right.
But other entities have qualifiers who may live overseas or may have business dealings overseas. So I can't say for sure, because it's a good portion of the whole project has some international components, and we've got to check in with them. They were just interviewing someone, recently, they did a Skype interview with someone, from overseas. So, and once all the information is compiled, we do interviews of, these qualifiers or people that are involved in these entities, and you need to have all your information before you can prepare for your interviews. So until all the, you can't just go do your interview and then wait for the supplemental document request to come in, because you have to be prepared and figure out what questions you need to ask. So that's, there's a structure for the investigation. Also, there may be entities where we have to do a secondary interview based on some more information that we get. So they're working on it, they're scheduling them. I do not think that those investigations will be done by the middle of June. I think there's at least a few that will definitely go over that time period.
We have the end of June here. You're suggesting
Yeah,
it could really go
Yeah.
further
At
than
least-
that?
At least one, maybe a few more, I think will take some more time.
What's the,
Based on what you're
what's the
saying.
status of all the redaction stuff?
So the, as I had mentioned previously at a previous meeting, the state police, once the redacted version of the application pursuant to the specimen form that was posted online those came in, the state police checked all of those. They found the majority of those were replete with problems, mostly over-redacting, there was some under-redacting. So they went through all of that, which was more than 21,000 pages. So as a result, because we could not just release those forms because they had errors throughout them, we went through several options of how to do this, and eventually we came to the determination the most expedient thing to do was to have state police take the original form again and re-redact it, because to unredact their redacted version just because of the software, it's very onerous, because you'd have to add in the information that they had taken out. So it's easier to just go through the form and use the software to redact. So they're in the process of doing that right now, which is, it's a drain, on our resources, having had to go through that before, and now having to go do this process where we basically re-redact all the original forms. That is draining our investigative resources, and it was an unforeseen,
Right.
expenditure of our state police time. And the state police are heavily involved in the investigation, so, we're managing as best we can. We're prioritizing the 11 entity applicants, the license holder applicants, and the expectation is once we get through all that, we can release those first, so we can get moving on the process, because I know the public has a great interest in looking at these.
Right.
So the entities, they have made requests for additional redactions, the formalized process. I've already responded from the IUB what our determination is on that. I have received some requests for reconsideration on that. We'll hear those. And then if they want to appeal that decision to the full commission, they have a right to appeal that decision to the full commission before that information is released. They also will have an opportunity to look at our form and say, this is what's going out. So before anything goes out, they'll be sent to the applicant. They'll have, I think, either 7 or 10 days to look it over before anything goes out. So they'll get to, check for clerical errors, and then those forms may be released. But I expect that would be on a rolling basis, because it just takes too long to do, all 300 of these
Right.
all at once, because that's a big project that we're also working on while we're doing the investigations.
Okay, I want to just clarify this a little bit, because I think this is important for a lot of reasons. First of all, there are a lot of people that have asked for, including Freedom of Information Acts, asked for the RFA1 applications, which we will deliver to whoever wants them as quickly as we possibly can, but we cannot do it until the redactions are done properly. And as you just explained, because there are so many pages
Right.
of stuff, that is taking a while, and it's an iterative process going back and forth with the bidder. But secondly, when you think about fixing the redactions, one would think, well, just it's just a clerical problem, get in a bunch of clerical people, but of course, the information in these applications is the most sensitive information that all of our bidders have, and it is protected by appropriate exemptions throughout both our law and the public record law. So we have to use people with security checks to do what is a clerical function of fixing the redacting. The people with security checks were our state police, so we had to take the backbone of our inspection process and do what the bidders should have done in the first place, which was get the redaction right, and tie them up, still, it sounds like, in cleaning up the redaction, which has taken a big chunk of our investigative resources out of the investigation process and had to put them into this clerical process. So there's two consequences here as a result of simply the bidders doing a lousy job of doing the redacting in the first instance. One is it's slowing us down in our ability to get these forms accurately released to those who want it. And two, it's slowing down our investigating process by tying up our state police doing the job of the bidders in the first instance. And then I want to make sure that press and public understand that, because it's, you know, it's an important distinction. And we've always said, we'll make our deadlines, and we'll get to this. We're probably still pretty close to our deadlines, but we've always said repeatedly, we can make our deadlines if we get really buttoned up cooperation from our bidders. And this was one place where we flat out did not. I mean, there's nothing, no bad guys involved here, but it was just not a good buttoned up job of responding to the required information, and that has had a negative effect on a lot of important things that we were trying to do.
It also, if I could just add a coda to that, is an experience that we need to look at for the second phase. It seems to me, and part of the problem, as you described it, is that we're prohibited from releasing certain information, not just that we're trying to protect certain,
Right.
we're prohibited.
We're
from
prohibited by law, right?
by law from releasing certain private information. And it seems to me that we ought to think very hard on the next go-round about including in the application that the bidder sign a release from the statutory privacy issues for information that could be protected, but that they've failed to indicate should be protected. Doesn't deal with the over-redaction problem. We still have to deal with that, but it would reduce a substantial amount of this Sturm und Drang. We need to think about it.
Yeah.
Because we've just spent too much of our resources doing this, and we can't do that again.
Yeah, that's a good point.
And in addition to that, a point you've made before, which is to really identify what's all the information that could be
Right.
Intellectual property, et cetera, and really call that out as a separate attachment
Right.
from everything
Right.
that is not.
Right. Organize it.
Organizing it in a way.
Right.
I know by necessity, the RFA, the phase one had to include in the same form
Right.
private and non-private information, but we may be in a better position on phase two to be able to call it out, if you will.
Yeah. Yeah, that's a good point. You're finished with, are you finished with
Yep.
your, yeah.
Could I, before
Sure.
Director Wells finishes, I've now read the regulations.
Okay.
And find out that I was dead wrong, so.
I was hoping
And it
that was
does.
the case.
You know,
All right, shall we go back here then to?
Yeah, let's go back for a minute.
Okay. Here is category 2 process.
Yeah. So because it does have an implication for our next topic. And so the regulations provide this, that the Bureau completes its investigation,
Right.
prepares a report, submits the report to us and to the applicant. And the applicant, if there's a negative finding in the report,
Mhm.
has 30 days to file a claim with us, seeking to challenge either a conclusion or a factual finding that's in the report. If there is no negative report, then we can proceed, but in either case, we have to have an adjudicatory hearing and make a finding as to qualification. So we can make that, we can have that adjudicatory hearing, we have to give public notice that we're gonna have it, we have it, we make the finding, we can do that quickly if there is no claim of error in the IEB's factual findings or conclusions. If there is, then we have to give the applicant 30 days to file with us its statement of why the finding or conclusion is wrong.
So is it, just for purposes of clarification for me, if there is potentially some information in there they don't agree with, but ultimately there is a finding, a recommendation of suitability by the IEB, do they still have the right to appeal that
They have the
issue?
right, our reg says they have the right to file a claim
Okay,
and have us decide whether a factual finding or a
Okay.
conclusion is wrong.
okay.
So we all, especially me, stand corrected about the title of that activity. It is indeed the review of the commission of that report that starts on May 1st.
No, I think not. I think the IEB needs to, at the end of the conclusion, prepare its report. So I think you still have an IEB processing period,
Okay,
right? Which is that what now denominated MGC review. Then they file with us and with the applicant. And the hearings can start right then for an applicant that gets a completely clean bill of health, right? Because there's nothing they're gonna challenge. So we could do that, we could have a hearing, post a notice, have a hearing.
No
and
one shows up.
Come to a conclusion, and forward we go. So the hearing period opening on the 29th, or whatever date, as soon as the IEB has finished its review and given us its report, still is fine. But we have to allow, at the moment at least, a 30-day period for claims to be filed with us in the event that the IEB comes out with an application that contains
But
a
is
negative
it,
finding or conclusion.
so is a 30-day period, as represented here, does it start on May 1st or May 29th?
May 29, which
Okay.
start from the time the IEB gives its report to us and to the applicant.
Okay.
It's probably somewhere in between, as a practical matter.
It's a practical
Yeah,
matter.
if I can get it
couple
done
of-
earlier, I'll
Right.
get it
You
done
probably
earlier.
take a couple of weeks to prepare your reports, so maybe the first 2 weeks here is IEB preparing reports, then say middle of May, you make your reports,
Yeah.
and then the 30 days run, but it's still,
Yeah, except for there's that, 3 of the 4 I think that would work for, but, the fourth one might
Well,
not.
fourth will take a little
Yeah,
longer,
that
yeah,
might push that
right.
back a few weeks.
right.
So the aggregate time, I guess, is fairly close.
I think so, right, I think so.
But the applicant will get that 30-day window,
Right.
so we're sort of on
Right.
hold potentially for
Right.
30 days
Right.
while they have a chance to review it.
Right. Okay, I just wanted to go look at, now finish back up on category 1. So at this stage of the game, the completion of the background checks on our schedule is 6/28, which isn't even 6 months from 1/15. So maybe January 15th, which is 6 months.
July.
Sorry, July
Yeah,
15th, sorry.
Even there,
Okay.
I just don't want to set expectations that I
Yeah,
can't meet.
no, that's
And
fine,
I am
yeah.
concerned, particularly with one we've got some issues we're really looking hard at,
Right.
with the nature of investigations. You just don't know till you start, and we're being very thorough, and we are really including Massachusetts and our state police in those investigations. We're not just sending it off to a company to do their investigation and
Right.
just get a report and sign
Right.
off on it. So, given the nature of that and some of the issues, we're looking hard at some things, and I don't think I'd be being honest with you if I said, oh yeah, I'll get it done by the 25th, because I don't think that's
Yeah.
true.
What's the best guess? And I guess, we can always change it back, we
Yeah.
can change it further, just for planning purposes.
At least sometime into August. Maybe if we could push it mid to late August. There's one that I'm concerned we won't get done by then, but I'll just keep you posted on that. The remaining ones, I think, probably in good shape.
It's also, they don't all have to be, you've got 7 of them, some are gonna
Yeah.
be done sooner, some are gonna be
Correct.
done later.
That's right. And, expediting, the slots licenses, they're really working hard on doing this, and they're using their resources on the slots, which means a lot of, the work on the other ones, although they're making the requests and doing the documents, a lot of the interview time and all that, they're spending on the slots. So I think that's I think that's factored into that a little bit.
Right.
Director Wells, you anticipate rolling recommendations, correct?
I could do that if the commission would like it that way, yes.
Does that make more sense? In other words, you have, if we're talking just the category ones now. Let's
Right.
put the category twos aside. And one is done, say, in June.
Yep.
And it was a more straightforward
Yep,
investigation.
and there are some that are easier, yes.
Prepare a report and start that process of delivering that to the commission as well as the applicant. Does that make more sense than waiting until all of them are complete to move the process forward?
I think that would be more expeditious,
Mhm.
you know. I don't know if there's concerns, maybe you want to group them, like do all the,
Region
Region
A.
A and then
Mhm.
Region B,
Right.
something like that. I'm willing to work with the commission however they want it presented, but yes, my expectation, there will be some that will be done sooner than others.
The doing it some sooner than others would only make a difference in the end, a real difference, if we group them by regions, right? Because once we.
Because you can't go forward. If there's one laggard,
Right.
you can't go forward with
Right,
RFA two,
right.
right?
So you could conceivably think about the one that was gonna take the most time, you wouldn't have to reveal who it was, but the region that one is in could be done after the region in which the others were done. And then
But
you
it
could
does
move
relate, I think doing it on a rolling basis does do a couple of good things. One is it stretches out our workload rather than
Right.
plunk it all
Mhm.
down
Oh,
at
that's
one
right.
time,
That's
A.
right.
And B, it gets communities set up to do their referendum depending on how we resolve
Oh, you're
that
right.
issue. So
You're right. You're
I
right.
think doing a rolling presentation of decision-making of
Right.
suitability does make sense.
Mhm.
When we get further into it, we'll see whether we can do a group. Maybe Region
Right.
A or Region B will get done, all of them will be done, and we could do that, make that determination sooner. But we can cross that bridge when we get to
Right.
it. But I think as a presumption, we definitely would want you to come give us
Okay.
suitability recommendations on a
As
rolling
we go,
basis.
okay.
Yeah.
And I think it's important to note that because something takes more time doesn't necessarily mean there are problems or
That's
issues.
correct.
It's
That's
just they
correct.
may have many, many more,
Right.
a much larger corporate structure, which
Right,
obviously
right.
takes
There
more
are some
time.
entities that have, a fraction of the qualifiers that
Yes.
other entities have, and
Right.
that's just, doesn't
Right.
make any,
Right.
difference on the time.
Okay, so we don't have a lot to talk about here, but again, in anticipation of Ombudsman Ziemba's presentation and in our conversation, so it could be that one or more of the background checks will drag well into August. And conceivably, so, who knows?
Right.
If one or two did drag into August, we still might be on this schedule. We're just not gonna really know, even with the potential hearing
Right.
problem.
Right.
So I don't think we know probably enough to make any significant changes in this yet. But it will get us to some other
Yeah.
topics.
Yeah.
Okay. Anything else on why don't you stay here, because once
Yeah, I'll stay
John
with you, John.
finishes his report, then we're gonna come back and look at this one more
Okay,
time.
all right, I'll take it.
Thank you, Director.
Thank you.
Thank you.
No, I meant, don't go away.
Okay. Oh, you mean don't go?
Yeah, well, whatever, you might as well
I'll
just.
just,
So we're now on item number 4, public information, education and information, and the report from the Ombudsman.
Thank you, Mr. Chairman. I think that today's discussion is going to be predominantly related to the timeline. The commission has asked me to talk to host communities to determine whether or not they will be able to meet some of our aspirational deadlines that we put forth. Specifically, we put forth a September 1st aspirational deadline for award of licenses under Category 2. So we've asked each of the host communities their opinion on whether or not they'd be able to meet that. Because it's about the same time as the special election date, June 25th, we've also asked the communities on whether or not they are anticipating that they would take advantage of that June 25th deadline. So the June 25th deadline and the roughly July 1st deadline by which applicants would have to have, applicants for Category 2 licenses would have to have their referendum completed, they're right about the same time. So In
Say
order,
that last sentence again. What was that? Just,
so, but if we have a September 1st aspirational deadline for award of licenses
of category 2.
of Category 2.
Yeah.
The referendum would need to be completed basically on or before July 1st in order to enable us to evaluate the applications, hold the public hearing that we're required to do. After our hearing, there's a 30-day window after our decision. So if you back forward September 1st, roughly, you at least need at least 2 months in order to evaluate all of those applications. So applications would need to.
If the RFA 2 application came in the day after the referendum, you're saying that would give us 2 months,
Basically.
which would be the minimum we would need to make the ultimate decision on category 2.
Right.
Okay.
So coincidentally, the special election date of June 25th and July 1st are roughly about the same
Yeah, I
time
see.
period.
Okay.
So I'm mixing apples and oranges, but when it
Yeah.
comes to the timetables, I think it's sort of instructive that I go through the laundry list of all the communities to tell you where they stand.
Right.
And then I'll go more deeply into the Category 2 schedule. So to start with the Category 2s, Rainham reports that in order to have the referendum on June 25th, they would have to have an agreement in place by basically April 25th, and that they report that that would be impossible.
They would not have a host community agreement ready by
April 25th.
Okay.
Worcester reports that a longer deadline is better and that September 1st is almost unworkable. Plainville reports.
September 1st as an award date.
September
Yeah.
1st
Okay.
is an award date. Plainville reports that meeting the requirements associated with the September 1st deadline is certainly doable, and that what is problematic is not having a firm target date. It's engaged the consultant that will meet any deadline that the town sets. However, the town would find it very problematic if the consultant were required to complete a fairly onerous amount of work in a very compressed time frame, only to have the date moved out. So as you can imagine, everybody is sort of reacting to whatever deadlines we put forward.
Right.
And we've discussed this in the past, of the importance of setting concrete deadlines. The Cordish proposal, PPE Casino, as you know, it has not selected a host community. Therefore, it'd be almost impossible to have a host community agreement in place by June 25th.
By April 25th.
Correct,
Yeah.
by April 25th in order to have the referendum for June 25th, exactly, excuse me. On to the Category 1 applicants. West Springfield does not expect to hold the ballot election concurrently with the special Senate election in June. The election will more likely take place in the summer or in the fall. City of Springfield is hoping to be able to meet the June 25th date. As you know, they previously reported that they are hoping to have the referendum in June in their RFP documents, but they clarified that they are hoping to be able to meet the June 25th date. West Springfield does not expect, I think I went over that one, right? Everett reports that it plans to hold the referendum by the Senate special election date or earlier. Palmer reports that it will not use the June 25th Senate special election date, but that the referendum may be held in September. Boston and Revere have not provided an official answer to our request. Therefore, it cannot be stated with certainty that they plan to use the Senate special election date. I do note that the deadline for the environmental certification on the ENF proposed by the applicant is due back from the secretary tomorrow, and that's a very significant document that will have to be evaluated by both the city of Boston and the city of Revere. But again, they've been evaluating these impacts for quite some time. Previously, in conversations, in testimony by the city of Revere, they provided testimony that they didn't want the commission to be involved in the question of whether or not we have to have suitability determined prior to the referendum, noting home rule as an issue. So that is where communities stand.
We must be missing somebody. Milford.
Oh, excuse me. Milford reports that it will not be able to meet the Senate special election date on April 8th next week. They have a tentative plan for a visit from the applicant to the Board of Selectmen, but, to date, no significant details have been provided to the community about that development. So, in conversations with the community, that date would be impossible.
Okay.
So
Can we-
just to review the bidding here, 3 of the 4 Category 2s say they can't meet the June 25th date.
Yes.
And 1 or 2 of the Category 1s say they can, the other 5 say they cannot or will not.
No, 3, Springfield, Everett, and Boston Revere say they would like to, could.
Well,
didn't see-
Springfield and Everett say that they would like to. Everett is more firm on whether or not they plan to go forward. And Boston, we have not received their official response.
But in previous times, they've said that that's what they're looking for.
I don't think they've ever made an official position of when their election date has been, but they have provided testimony to the commission that they wanted us to not be involved in tying.
Managing that, yeah. Okay.
So we've got 1 firm, 725 or earlier, 1 aspirational, 725.
Yes.
And the other
625.
5,
625.
625.
Yes.
And the other 5 are, according to the most recent survey, either silent or no.
Yes.
Okay.
Could we talk about the Category 2 in particular? Because it occurs to me that the aspirational date of September is less and less feasible. And we'll be talking about these in the scenarios, but you may recall scenario 1, moving the current schedule as it is now contemplated further up appears impractical. See the first statement?
I think that's a fair statement.
Yeah, I mean, it sounds like Plainville is being flexible, but the other 3 are clear, they can't make it.
Mhm.
Okay, even if we could make it, right?
Right.
Okay.
So, in regard to the schedule, I don't know if you want to look at the licensing schedule scenarios that previously we've discussed. And there's important policy considerations that go into each of these different scenarios. The scenario 1 roughly anticipates what I just discussed of a July 1st date. It allows for another additional couple of weeks into July for the referendum to occur and the submission of applications to us. But the scenario 1 is roughly what I just discussed. Category, the scenario 2 that we have in here provides a little bit more flexibility for the completion of the referendum. But what's notable about this date is that the award of licenses can occur earlier than our December 2nd date. But it still anticipates some difficulties with meeting our schedules based on what we need to do for protocols and procedures. One thing new about all of these schedules is they incorporate our recently proposed procedures for resolving disputes between hosts and surrounding communities. And even though we believe that that's a sort of very efficient process, there is a good number of days that need to be added into the calculation of our scenarios, if indeed we have basically even one potential surrounding community that goes through that process.
Right.
Because if you have 4 applicants, you obviously cannot make the award until you go through the process
Right.
with your surrounding community, well, whichever applicant it is. So if you take a look at the scenario 2, what that anticipates is an election date that occurs basically in the summertime. Scenario 2 If you look at the summary that's been provided by our consultant, it says that the host community agreement shall be executed no later than June 3rd, 3 months from today, and that the HCA referendum shall be no later than late July or early August. With a referendum no later than late July or early August, you obviously have the issue of what happens with voters who are on their summer vacations. Do you have questions about the referendum from the electorate? And again, I don't believe that everybody goes on vacation at the same time, but it has been stated as a concern by communities and by other folks who have reviewed this process. The host community agreement executed no later than June 3rd, 2013. That likely is, in my opinion, it is potentially doable by a majority of the Category 2 applicants. The Worcester proposal, they would have to do some serious work between now and then to get into their host community agreement.
And Cordish too, I would think.
Well, in the fourth one, because there has been no site identified, it's probably less on the border of whether or not a June 3rd
Yeah.
host community agreement is possible.
Right.
You know, from Worcester's perspective, even though they said a September 1st is almost undoable, anticipating the April 25th host community agreement, there still is a good amount of evaluation of the proposal that they would need to do, and to the best of my knowledge, they haven't begun that work with a consultant, so they would need to get a consultant on board very quickly in order to start doing those reviews. So I don't know, Mr. Chairman, if you want to talk about some of the issues regarding summer elections, or do you want me to go into the third scenario?
Yeah, I think so.
Okay. So under the third scenario that we've crafted, this anticipates that the commission would be able to award the license earlier than we currently propose, under the best situation. So under the scenario 3, the commission could award a Category 2 license by November 6th, which is roughly a month earlier than we currently propose. But that, again, that's under the best of all circumstances. If indeed any of one of these applicants have a surrounding community issue that has to be resolved, the date could extend to 12/22, which is roughly about 3 weeks after our current timetable. But this schedule does reflect some movement, so that we were able to move the schedule a little bit forward compared to our current schedule. But that if indeed things do not go well on the surrounding community issue, it would be at least a couple of weeks after our current deadline.
Okay.
And the scenario 3 reflects a referendum date, which is scheduled for early September, after Labor Day. So applicants would have to submit their applications no later than September 10th, 2013, under scenario 3.
And that would give us, never mind the surrounding community issue, that would give us just barely 2 months to do the review, to make the decision.
Correct.
Is that referendum date feasible in your judgment for everybody?
I think so. Again, we have an applicant that has not identified a site, but in communications with that applicant, they have said that we can publicly report that even though they have not identified a site, that they have been doing the due diligence on that site, such as at the time that they announced that site, a lot of what goes into designing the facility and determining some of its impacts, such as its traffic impacts, will be available by the time that they make a public announcement. So, given that statement, and again, we have no documentation to back it up, but given that statement, it may be much more doable rather than an applicant that announces on one day and then says, well, we need several weeks or months to review the impact and then make that information available to communities.
So they'd have 3 months basically to get their act together and do the host community
Yep.
from now.
3 months from now, meaning, yeah, because you'd have to announce the election in July 1st or
Yeah,
10th or something.
first week of July and the first week of July.
So that might leave them with a pretty tight timetable between the time of their announcement and a host community agreement. So, for example, if that applicant comes in, it's now April. If they come in and make their announcement on site in May or late May, then they would have basically 1 month to execute a host community agreement with that community.
Yes,
So-
and that's a value judgment that we have to make.
Yep.
The applications were due January 15, and were filed January 15. So,
Well, I think we have a series of decisions to make here. The first question, we had raised the issue of can we move the Category 2 license award back even as soon as September, if not September, some other date. We clearly cannot move it to September. At least 3 of the 4 couldn't make it, even if we were ready. So that September 1st is off the table, or early September is off the table. My sense at this point is that we might as well leave our deadline where our deadline is, which is the first few days of December, and not try to do a lot of angst for everybody to pick up a month or two. The month or two in the end of this is just not gonna make a lot of difference in the end of the world. And everybody now, not just our background checks, but the bidders and the communities are now coming to grips with how complicated this process is, and are beginning to say, whoa, ease off a little bit, give us some time. Even the Plainvilles that are ready to move really quickly if they can would just as soon not get really pressed. So my suggestion would be, and this is just to get the conversation going, my suggestion would be that we formally decide to leave can you go back up to the schedule as it is? That we leave the deadline, the targeted award in the first week of December with a dotted extension if there's a surrounding community problem. But I wouldn't want to move the deadline out to January in order to accommodate the possibility of a surrounding community problem, because we want to keep the pressure on the bidders and the surrounding communities to resolve these issues. We don't want any surrounding community problems to come to us. We don't want to delay this thing. So I think we ought to keep the deadline, but we ought to keep the deadline in December, but also we can demonstrate that if where are we now? All right, so, yeah, 12-2, commission awards category 2. And then we have underneath this the green dotted lines that suggest there could be a problem if there's a surrounding community problem, which I would leave like that. And then as we work with the various communities, I'm sorry, so if we leave December 2nd, I think we also have to set a deadline for when the RFA 2 proposals have to be in. We can't let somebody who hasn't picked a site yet push everybody else later with their RFA 2 applications. So do we have yes, we now have
Deadline is August.
10/5, December, so what's that, October 5.
Yeah, as the category, as the phase 2 deadline.
As the RFA 2 deadline.
Yep.
I actually would be inclined, well, maybe, I don't know. I mean, I'd be inclined, that only gives us 2 months, and we can probably do it in 2 months, but it'll be our first round through, and there's a ton of time prior to that. I would be half inclined to move the 10/5 deadline back to at least, September 15th, so that the first week, if they want to have their referendum after Labor Day. They have it the first week after Labor Day, and then they submit the RFA2 application, which is ready to go momentarily thereafter. If they want to have a referendum in the summertime, that's their business. They can do what they want. So there's my straw man for people to react to. So the long and the short of it is, leave December 2nd is our expected award date, subject to the wrinkle if there's a surrounding community, and move the submission for RFA2 forward by a couple of weeks at least, a couple, 3 weeks to mid-September.
And that, then we have to talk about and contemplate those host community agreements, because that October 5 deadline comes from the three places, from the host community, the surrounding communities, the preparation of phase 2, all of which are not driven by this commission, but by our applicants and colleagues in the local governments.
Right. But they've got, I mean, well, I mean, it's just a judgment call. I mean, it seems to me, from what I can see, that there's plenty of time for surrounding community, host community, and the RFA2. So when we release the RFA2 application form, when?
June 7th.
June?
When we finalize the phase 2 regs, the idea is that the,
Okay,
as
right.
with the phase 1,
Right, okay.
that application form would be ready to go.
So the first week or so of June, we
Right.
release the RFA2 applications.
Right.
That would give them June, July, August, September, 4 months.
120 days there, 4 months.
Right.
It's the orange bar for them to prepare the application.
Is that 4, oh, that's 4
Yes.
months, yeah. okay.
So moving that up 2 weeks should not be problematic.
It's
Well,
really a
except-
question of whether.
Except that it does move the deadline for the, no, strike that.
It's really a question of whether we could take a couple, 3 weeks away from the bidders to get their side of this work done and give it to us. So we've got another couple, 3 weeks to review the RFA2 applications and still make our decision on time. I mean, maybe I'm fine tuning this too much. I'm a little bit, I mean, and if
There's-
sorry.
I'm sorry, regarding the preparation of the applications, it occurs to me that applicants out there may be waiting for a referendum, for the result of a positive referendum, to spend additional resources necessary in preparing and submitting that application, to the tune of really designing, studying further the impacts, if they haven't already. It's something that we don't know about. It's something that we don't control. But as we should just keep in mind that the preparation, that orange line, is not just contingent on us releasing the form. It is contingent on something going on locally and internally with our applicants. And that has to do with whether they believe they can and should spend a lot of resources fine-tuning that application if they don't have a positive vote.
But if they don't have a positive vote, they're done for 180 days, right? As a practical matter, they're done. They get one shot at this deal.
That's right.
And so, there may be things that, your point though, is certainly valid, in that there may be things that come up during the election process that they want to fine tune, notwithstanding the fact that they got a positive vote on the
Referendum.
On the referendum. It may be, for example, that a surrounding community has a particular issue, and it really provokes a lot of intensity, and they can figure out a way to fix that in their ultimate presentation. And it's the referendum process that will surface some of those issues. So that favors giving the applicants as much time as is consistent with trying to meet the December deadline to let this process cook, if you will. And my sense, Mr. Chairman, is that a couple of weeks isn't gonna yield that much, that we have from now until the application deadline to put into place a team to evaluate
Process,
things
right.
and a process. These applications, by their nature, are going to be complicated, but less
Lesser
complicated.
than, right.
And that's sort of a dress rehearsal for the others.
Right.
And this schedule has been out there since the beginning, and unless there's a real, there's real value to shrinking now the time, even slightly, we ought to just leave it alone and say, and then begin to enforce rigorously the deadlines that are necessary for us to meet it.
Right. I agree with that.
Mr. Chairman, one thing I will note is that, and I don't know if Worcester is planning to utilize this date, but well, Worcester has an election on September 17th of this year, sort of in the middle of the month. I'm not aware
Oh,
that.
a municipal election?
Yeah,
Okay.
I'm not aware that either Raynham or Plainville have a fall election.
Yeah. I think I agree with what Commissioner McHugh said, you know, and so I agree with that. Have you, as you and Commissioner Stebbins have been talking to people, agencies that do review of big proposals, have you picked up anything that gives you a sense of whether we've given ourselves the right amount of time to do it?
I think it's tight, but I think it's doable. It really depends on the team that's in place and how much upfront work and preparation work goes into getting ready to receive the applications.
Okay.
But
Well, we've got time to do that.
we have plenty of time to do that, and I think we will begin to work on fleshing out an approach next week with our executive director. And so I think it's aggressive, the 2 months, but doable.
Okay.
We should note, though, that at least in theory, for Category 2 proposals, which would be the first ones to come to this commission, we've allowed the early submissions, if they happen, in this blue line here represented right after July 26th.
So which line are you talking about now? Down? Blue line?
Yeah, it's, I guess it's dark blue right there.
Here.
July 26th. No, it looks more gray.
Gray.
It's blue in the
Right,
screen.
that's the one.
Here, okay.
July 26th, there is conceivably, after the determination of suitability on July 25th, that somebody could come in as early as then.
Right.
That's true, that's a deadline for
That's the
receiving the
dead-
That's the
application.
deadline for
Yeah,
receipt,
right, so-
but we could be in a position of evaluating the early proposals.
So which would, yeah, that's a good point. We don't just have the 2 months, we have the 2 months plus whatever we get if anybody comes in
Early on.
beforehand.
Right.
Yeah, good point.
Right.
It would be to people's advantage to get them in as early as possible.
Right. That's, we did not have that big activity, if you will, on Category 2, but this is, I'm sorry, on Category 1, further up on the screen here.
We didn't have the
We
early.
have the same kind of thing,
But something the same theory applies.
Right.
That any time between October and
though. Right. And the
January
deadline.
1st, and the deadline, the actual deadline, there could be somebody submitting.
As soon as the suitability determination is made, we're ready to take a Phase 2 application.
Right.
Assuming that
So this,
everything else is.
so this is okay, this evaluate proposals after 10/16, that's actually the same as Category 2 evaluate early proposals.
Right.
That's right.
Move that, can you move that a little bit
Yes.
further to the right?
Yes.
Oh, I see, okay, yeah, the same thing, okay.
2
Great.
months here,
We've
but
left
there could
ourselves
be
a little
early
more time.
proposals here.
Okay. So do we know anything, so I think category 2, we've got a consensus, right? We're just gonna leave it as is.
Can I make one more point? Before we, if we decide that, and communicate that, if our applications could be, or should be submitted in pieces, let's say, if there is a piece that's ready, let's say, all things mitigation are Roman numeral 4 in our evaluation criteria.
For finance.
Just for the sake of argument. That could be received by this commission, put forward to some analysis, while they're also preparing, that's again, for the sake of argument, other pieces of the application.
Right.
Unless we wanted for the application to be all complete before we actually saw it. That's something that I'm just throwing out there as we're contemplating this schedule. I don't know if it's practical or even desirable.
Seems to make more sense to me to have a complete application. Then we can check it for completeness, have a process in place. It just doesn't sound to me that the piecemeal application, are you aware of projects that?
Well, preferably, yes, we would need a complete application. But if there is a way to parcel it out, because the criteria, our advisors, the teams, et cetera, would lend themselves collectively to that evaluation, it's just an idea.
Certainly worth considering. It's conceptually, and
We'd have-
the draft regs don't contemplate that. They contemplate, and this one I do remember, I think, a determination of administrative completeness before we move into the substantive analysis. And it might be a little hard to figure out, for example, the adequacy of the mitigation plan until you know and knew what was being mitigated. But it's certainly worth thinking about, and we
Right.
have until the regulations are promulgated to continue to think it through and see if we can tweak them. Find chunks that we could get earlier and encourage that to happen.
We'd have to be very clear as to
Right.
what we would allow,
Right.
because we could be in the scenario that you allude to, Commissioner,
Right.
where somebody interprets as, well, I have plenty of time to do that, and not that.
I think there's a second consideration we would need to think through, which is, at what point would an early piece become public?
Right.
Because a bidder might not want to put their information out before other people have put their information out in order, so. But having said that, I think thinking this through is entirely appropriate, and we're gonna be having this process conversation
Right.
over the course of the next few weeks, and, maybe we can figure out a way to do that.
Financial pieces may be isolated.
That's what I was thinking
Right.
too, right, the
And
finance.
they're largely confidential.
Right, yeah, good point. So it's definitely worth thinking about. Okay, were you about to say something?
Nope.
So I just wanted to take a quick look now at category 1. And it looks to me, and the question that, as I was preparing for the meeting, that I wanted to ask is, are we on track, as best we can tell, for category 1 to be awarded in the February, March area next year? And it looks to me like we believe there will be some delay of 1 or possibly more. They'll definitely be later than June 28 for most of the background checks. Yeah, and there may well be 1 or more that drag in as late as August. Having said that, though, if you roll the line on out, with all the various cushions that we have built in here, like the hearings appeal, that we don't know anything now that would make us rethink our deadlines. I mean, so far, so good. You know, even with some of the problems that have arisen, I think my sense is we're fine for category 1 as well for the time being. So the one remaining question is, do we, given what we now know, which is that no category 1 players are pushing for the right to have the referendum on June 25th. Sorry, category 2 players. And the category 1 players, Springfield is hoping for it, Everett would like to do it maybe even sooner than that, and Boston Revere, we don't know. So the question comes, do we want to reconsider the decision that we made, which is to preclude a referendum prior to the decision on suitability? And I think we do need to discuss it there. I think the communities, there was a lot of emerging pressure from communities, which has begun to ebb as they've come to grips with their own problems. So it's not as pressing a question as I think it was even 2 or 3 weeks ago. But it's still a question, and I think it is something we need to talk about. Jump right in.
Jump right in. Well, I did want to talk about the funding for the investigations, because if, for the sake of argument, we were to say there's no longer a constraint, and with an ongoing investigation, we may be in a position where Springfield, notably, and I'm just speculating here, could very shortly decide on only one applicant, at which point to put it on the ballot and to try to meet the June election. We'd have to look at how much, practically, one of the other investigation could have to be come to a screeching halt, if you will, or it may not. I'm just speculating here. So we'll have to look at how much resources have been funded, are being spent, and we would not want to be in a position of having to have that applicant give us the remaining of funds, let's say, if those expenditures are over the $400,000 application fee.
I'm not quite, so are you concerned that they might owe us money, but
Yes.
they're out, and therefore we might have trouble collecting our money?
Technically,
the
yes.
issue?
That's it.
Yeah.
That's it. All applicants, some very little, but some significantly will be over the $400,000 application fee. At the rate that the investigations are going, the burn rate is significant. We're at the thick of it. We get the bill from our consultants. That takes a few days to look back at the prior month, and we have 30 days to. We remit an invoice to our applicants, and they have 30 days to pay us. Because of that duration, we may be in a position
Yeah.
where we have less.
We have less leverage, but I hear that, but I don't think that's a good reason to make the decision. I mean, assuming that somebody might try to stiff us on the money, I mean, they're gonna have to continue to do business around the rest of the country. They might wanna do business elsewhere in Massachusetts. I think it's unlikely that one of these people is gonna try to stiff us, and B, I think anticipating that they might is not a very good reason for affecting this decision. That's just my.
I wouldn't characterize it as stiffing us. I would say they're less than incentivized to pay the costs that
How would you
that have been
distinguish
incurred.
that
Well,
from sniffing? Sounds like sniffing
just in
to me.
time, just in time.
Okay, well, I,
Well, even before that, we could call it stiffing us. We would have to make a quick decision on stopping those investigations.
well, that's true, but.
That perhaps goes without saying.
By the way, if
And
somebody-
we'd have to do some, tallying of all those resources. If they had been planned, if they had been scheduled for certain things that now are effectively no longer.
You know, I think originally we thought it would be best for the citizens to know about the financial wherewithal and the integrity of the company planning to build in their community. And I still think that's a very valid point. You know, we were getting the concerns by the applicants who said, look, we're spending all this money and we really want to know whether or not they want us here before we continue to. That was your point earlier, Commissioner. But listening to the changes really in the applicants who may not be ready now, who are hoping, but they don't know if they can meet those deadlines. I don't know if the rationale is as strong as it was at one point to consider changing our regulation, which now states, I know it's not promulgated yet, that suitability will be complete before you can actually have the vote. And then there was talk about, can you schedule the vote, but actually holding the referendum without a finding is a question. Now, I think it's really important, and I had this discussion with Director Wells, whatever we decide along those lines, that will not change the recommendation, the investigation, that there will be no change in how that'll be presented and what those recommendations will be with regard to suitability. I guess the question for me is how important is it for people to know that ahead of time? And that's the original reason we stated that. Am I correct in stating that was our original thought and why we wanted that vote?
Well, there were two.
The suitability first?
I think there were two reasons. One is we thought it made sense for people to know, but also we thought that we didn't want the community to go through all that angst and then have it amount to nothing, even though theoretically the bidder has to pay for the cost of the election. It's still a big McGilla for a community to go through if there's no other election. And we made that decision before we knew there was going to be a special election for John Kerry. So the issue of convenience
Yes.
was one of our two concerns. That one's gone away. The other one, apropos of June 25th, that one's gone away. The other one, the one you're talking about now, which may have been the more important one, is still right. Could you move this over a little bit? I just want to see, when were we anticipating referenda on the present schedule?
Anytime for category 1 or 2?
Yeah, 1. We need to move it, slide it over a little bit.
Let me,
No, just slide,
Anytime up to October 4, right?
October 4 was category 2.
Oh, I'm sorry, category 1.
Category 1.
So December 31st was the
Right.
deadline by which we were expecting category 1 referenda. Right, and that would have left us our couple of months to to process the applications, unless they came in earlier down here, right? Okay. So, in terms of our original schedule, that's June 25th is miles away from when we thought these would normally be taking place.
Well, at least for these, as represented here, the category 1 is really the latest of. It could be as early as the determination of suitability.
Right. Which
which
is-
for category one is October, or even earlier than that, if there is no hearings and appeals.
Right.
So we're only representing a latest case, a later date case.
It seems to me that there are four considerations. There is the cost consideration, but I put that to one side. Collapse the election into the special election or another election, and you save costs. But that's the applicant's concern. The applicant has to pay for those costs. And so the costs are there. It is a consideration, but it's not coming out of the public treasury. It's coming out of the applicant's pocket. The second is voter fatigue. We've been having a lot of elections here, and a concern about having too many elections and everybody stays home. I think this election has enough punch that people aren't going to stay home. There's energy around this on both sides, and it seems to me that's unlikely to be an impediment. Fatigue is unlikely to be an impediment to an active electorate showing up for these elections. On the other side, we said before that, and I'm going to quote now, it's absolutely critically important that the communities not make final judgments with people who have not passed the background checks. There's nothing more fundamental in our licensing and regulatory process than to make sure that the people who are in the game are people that we want in the game and who have passed the most rigorous standards. I don't think anything's changed about that since we said that. And fourthly, the past months have shown that this is an animated process, that people are engaged, and that rumors about people, their qualifications, their backgrounds, their dealings have proliferated. And it seems to me that by allowing an election to proceed before we finish the qualification process, risks injecting into the middle of an electoral process information that has not been verified, that may not be true, and that affects perceptions of the qualifications of the applicants in a way that would be unhelpful and distracting from the issues. We have this investigatory process, which really is something I think the public should admire, the way if people are going about this and the team that's been assembled to do it. These are dedicated people who are skilled and who are really digging. And it seems to me important to put to rest or to verify information that may bear on people's judgments before the election takes place, so that the election deals with real issues and not illusions. So I would be in favor of leaving the regulation for those reasons where it is.
Well, that's really well said. I hadn't thought about that last point. I think that's a really meaningful point. And interestingly, the two sites, Springfield and Everett, that we know are interested in having the election possibly before the suitability test, have bidders that are internationally involved, which is one of the places that's the most replete with misinformation and disinformation and so forth. And also, by definition, just from what Director Wells told us, two of the background checks are going to take the longest, so there'd likely be the longest distance between the referendum and the eventual suitability decision. So I think that's a very important point. Let me ask just one, what is, outside of the fact that some of the bidders want to get this done quickly, is there any loss in not permitting them to get it done until the suitability? Is there any public policy interest protected by giving them the option of doing it before suitability?
I'm sorry, can you, I was going back and forth on
No,
that.
is there any reason, is there any argument, a public policy argument in favor of giving them the right to have the vote before suitability? We just got 4 reasons why there's public policy reasons not to permit it. Is there, do we lose anything? Does the public lose anything?
Yeah, well, one of the.
Process lose anything if we don't do it?
One of the arguments that's been put forward by applicants is that certainty has a value to applicants. If they know that they are able to proceed based on an election, it is easier for them to expend the dollars that would be necessary for fully evaluating what they need to do with surrounding community agreements, for example, or to proceed a little bit more expeditiously with permitting, for example. So, you know, we've said that there's a minimum requirement for state permitting. We're asking you to exceed that minimum requirement, but to the degree that they don't know the feelings of the host community, they may be a little bit more reluctant to move forward with more expeditious permitting. And they may be a little bit more reluctant to be more forthcoming with dollars for technical assistance, for example, to enable communities to evaluate that. So there is some value for an earlier decision point.
Yeah, interesting. Anybody else? React? Opinions, thoughts?
You know, I was so focused on suitability will not change, no matter if there's a yes or a no vote, that will not change. Well, obviously, if there's a no vote, that would be a different scenario, but because people have voted, yes would not change the way we investigated, the way we brought forth findings. I hadn't considered the thought that misinformation could affect the vote. And that is, I think, a very important consideration that I hadn't thought of as affecting the vote, misinformation.
I mean, it's a very, take Springfield as a perfect example. The MGM case is already brooded about. There was whatever the transaction was in New Jersey. The public, the voters in Springfield are not gonna know what their regulatory agency thinks about those concerns. And that's a big data point. Never mind, people can throw mud or distort and so forth, but it's a critical data point. If you were trying to vote, you'd say, hey, I wouldn't vote for this if there was a real serious problem in New Jersey, but I would if either there wasn't or if it's been corrected or whatever. So I think that's a really significant point.
Mr. Chairman, can I put forward an argument that could be raised on that issue, which would be that potentially voters could go into the ballot box with the knowledge that they are voting on the proposal that's before them, but they know that the commission at some point or later or another may say yes or no based on suitability, so that doesn't have to be brought into their equation going into the ballot box. That's a potential scenario, but I guess I would also say that that sort of level of sophistication
Right.
of the voters is probably not existent now. And there's been no education efforts to date to, obviously because we have the existing policy, to explain to voters that would be the process.
Right.
So if indeed we did, if the commission decided to change its policy, one would have to engage in a very significant public outreach effort. One other thing I just wanted to mention, in some of our meetings, at least with one of the applicants, they put forward what has occurred in other jurisdictions, notably in New Jersey, where there is a potential of a preliminary determination by the agency of suitability, and at some later point, the final determination. I don't think it was in this particular context where you're putting forward for a vote, but it's in another context, and at least one of the applicants wanted to provide that as an alternative to the
I
commission.
see that as problematic. I see that, you're not completed with the investigation, so you're inclined to say, okay, they're conditionally suitable, which gives someone the idea that I'm gonna go and vote a certain way based on that, and later for us to come back and say that, oh, geez, we hadn't considered this, they're not suitable, I think is really problematic. Something we shouldn't consider.
So if we know what the host community is gonna do, we'll spend more energy and money getting our permits in order piece is important. I just don't think it trumps the other pieces. I think that the planning can go on at a certain level. I think the meetings with the various agencies can go on. We've arranged that. I know it's expensive. I respect that. But I really think that I don't think it changes my view, at least, of how the equation balances out. It's a close question, but it doesn't change mine.
And so many of the applicants are not prepared to vote on that June date.
And only one is foursquare in saying that they want to. I mean, they,
Well, Springfield wants to, but they're not, they hope to, I guess is the word.
hope to, right, yes, yeah.
But Springfield, when we were commenting on this, when we were considering this, said that the commission said that we ought to do this, that we ought to require the completion of the investigation, the qualification investigation before we permitted a vote, and that ought to be a uniform policy across the state, if my memory serves me.
Is that right?
Yes.
That's correct. Because it was based on, I think what it was based on, that they previously agreed in a letter to the commission that that's the process that they would
Right.
do.
Yeah.
Right.
So in order for fairness, they wanted uniformity.
Right, that's
Right.
right, that's how that came about.
Yeah, good point. Consistency is a hobgoblin of small minds.
And big ones too.
Yeah, right. Any other
Well,
thoughts? or-
I'm
A
persuaded
foolish
by,
consistency is actually what it's.
Yes, foolish
It's foolish
consistency,
consistency.
right.
Not always.
Good.
I'm also persuaded by the well-articulated points of Commissioner McHugh. I think there's value to continue the way we set out to do for all those reasons. So I'd be perfectly fine going along with leaving a regulation in place.
I'm just not thinking picking up on Commissioner McHugh's last point about the rumor, the innuendo, I think we're somewhat doing a disservice not only to the voters but to the applicants themselves by sending people into the ballot box with that just kind of air of complexity. I have no doubt that whenever an election is scheduled, that people at the local level will probably turn out in higher numbers than they will for a statewide election, albeit a special Senate election. This is something that I think they realize that the power of their vote is stronger as opposed to being one of however many votes are cast statewide. It certainly impacts their community more. I think we're going to see applicants and opposition groups spending money to alert people to whenever that date happens, and I think it's incumbent upon us that the suitability declaration that we're providing the voters in, again, I think we're helping both the voters and the applicants to be able to go into the voting booth with the best information that we can provide them as the regulatory body.
If, that sounds like we got a consensus and there's no reason, so I think we'll leave the reg as it is. Okay?
Now,
Thank
Mr.
you.
Chairman,
You had
one
some-
little subset of that regulation is that currently we still afford communities and applicants to schedule the referendum. But if we are not able to get them a determination of suitability by that time of the election, then they are not allowed to proceed. And the time period for the positive determination of suitability pursuant to our regulations is after the IEB presents it to the commission and after any appeals. That is the period under our regulation. So we've heard some commentary that, June 28th would be basically the earliest in some regards that would be able to meet that. I guess the policy, if we're sticking with the current policy, communities could still move forward with that date, but I guess they would be forewarned that we've had some testimony already that it is not likely that we are going to meet that date.
Yeah, I would say we would want to be pretty foursquare about that, and even public, which we just have been. We've just been public stating that we're, particularly for those entities which have international operations and linkages, we're not going to be making those deadlines. So I think we should be we should be pretty straightforward with people about that.
But I want to make sure I understand. There's a 60-day period that you're referring to, right? The scheduling and when the election takes place. Somebody locally could schedule a vote with some 60 days to go and hope that our forecast of the termination of suitability falls within that 60 days. Is that what you really, what
That's a
you're
current
alluding to?
policy, yes.
That's the way it
Right.
stands now.
Right.
And, I think relative to June 25th, that's pretty much off the table, just as a practical matter, that, for the people that are talking about doing it, Springfield and Everett, the likelihood of us making those deadlines is not good at all, we now hear. But if we leave that rule in place, that you may schedule in advance, you get around to the first Tuesday after Labor Day, then you'd have to schedule that in July, and we may well know by then that we're close to done. And we wouldn't want them to wait until the end of August when we finally conclude to announce their 60 days. So I think leaving the option open of scheduling without suitability, although it's tricky, and I grant that, I think it's constructive. Not now anymore because of June 25th, but because of the likely September elections, referendums.
So I guess my recommendation would be for any of those applicants and communities that were thinking about the June 25th deadline, including Boston and Revere, they should very quickly check about the status of our investigations.
Right.
And we publicly stated that at least for a couple of the applicants, June 28th would be difficult to meet. I'm not certain we've made a determination on all applicants.
No, we haven't. Right.
So they would be urged to communicate quickly with our IEB.
Yeah. And through you, probably. Okay, you had a couple of other things.
Before we leave this,
Yep.
could I just, a technical piece just occurred to me, and that is that the regulation that prohibits this, we have a policy in place that says no election until there's been a qualification determination. But the regulation that contains that is the Phase 2 regulation. The Phase 2 regulation has not yet been promulgated. It's in the promulgation process now. It won't be a final regulation. You have to take a look at the comments and the like, but it won't be a final regulation until June 7th. That's our target date. I take it that nobody is likely to have an election before June 7th. But if we have any concern about that, we have two approaches. One, to simply convey to the would-be host communities and applicants that this is our policy and we anticipate it will be a regulation and expect and hope that they'll follow it even though the regulation isn't in place. Or two, to adopt an emergency regulation next week, putting that in place. It seems to me that we're dealing with people of sophistication and business sense, and knowing that this is our position, even if the regulation isn't in place, they would not go forward, given what we've said about our intentions, but at least it's.
Actually, I'm glad you bring this up, because I think, that is true what you said about the people we're dealing with, but the same people are accustomed to getting their way and will push us and are pushing us as hard as they possibly can to get their way. And if we give them a window, some of them might try to take it, you know, so might as well be on the safe side and do a reg next week.
Well, I say next week, but certainly, let's talk with the legal team and see how soon we can get an emergency reg to adopt that piece of our regulations.
I mean, it should be clear to all bidders what our policy is, there's no
Right.
question about that, and we will stick with that whether there's a reg or not. But I also think, for the record, getting the reg done as soon as we can is probably a good idea.
One thing I would recommend is that bidders and communities might have something that we've never contemplated, and as is usual, they have the ability to, you know, present any ideas to us for our consideration, and we would gladly hear them. You know, with the one idea that was tossed out was the conditional approval, maybe there's other ideas about how people can meet it. I can't understand what that would be, but that's probably a good practice that we've always followed.
Well, we have always followed it, and I'm not suggesting we shouldn't follow it again here, but remember, this is the second time that we've done it.
Correct.
We did take public comments.
Yep.
The first time,
Understood.
we got 11, 12, 14 public comments.
Yep.
On exactly the same proposition, so that hasn't changed.
Right.
But that doesn't mean we shouldn't do it again and ought to think about that.
Yep. Okay, you had a couple of other things on your agenda.
I think the other thing that I'll report is that on our RPA election, you have a chart in your packet that shows that we have received unanimous either approvals or maybes from our applicants on whether or not they would like to participate in our process. So we asked for each of the different applicants to tell us whether or not they are interested in utilizing some or all of the RPA services, and that they will attend a planning scoping meeting, that they have not determined that they're interested in using some or all of the services, but that they will attend the planning or scoping meeting. And then the third category was that they are not interested at this time in using some or all of the RPA services, and they will not attend a planning scoping meeting. So.
This is missing Cordish and Worcester.
Yeah,
Oh, okay.
this is 9 out of the 11, and we don't, because we have no site for the 11th, there's no RPA that we could consult about whether or not they would be able to provide those services. But what I do report is that Central Mass Regional Planning Commission has told us that it would very much like to participate in our process, and that they said that they would, that we should utilize them in meeting the needs, specifically in the Metro West area. They have jurisdiction over the Worcester area. They have jurisdiction over the western part of the Milford proposal, and then a limited portion of the Palmer proposal as well. So conversations are ongoing about how regional planning agencies deal with multiple jurisdiction questions and how that is being dealt with. But that'll be part of the scoping planning meetings that we have with the applicants and the communities. We're in the process of trying to schedule those now.
Okay,
But obviously, we have to move pretty quickly.
right. Yeah, but that's great. I mean, I think it's great that so many people are interested in doing this. So I think this will make everybody's lives a lot easier. Anything else?
One other thing I wanted to mention is that we've attended some recent meetings where we've received comments about different things that the commission could consider. And along the line of our investigations, it hasn't been entirely clear to communities how they can provide information to the commission about anything related to the background checks. So if for any reason they find something that they think is worthy of our review, there hasn't been a formal set process by which they could submit comments to the commission. Director Wells and I have had conversations about how we would go about setting that up, and I think what we will do is we will put forward an advisory to communities on how they can put forward information to the IEB so that it can be put more formally into the investigation.
And that you would send out proactively to all the communities as well as post.
Right.
Yeah. No, I think that's great. We have heard that a few times, and it's important to clarify that. We want anybody who's got
Right.
information they think may be relevant to know what the channel is to get it into the mix.
And it fits within that other conversation that there shouldn't just be these sort of ancillary raising of issues. The proper channel for investigation is through the commission, we're investing obviously substantial resources into evaluating those and to determine whether or not they're real or not real, or with, seasoned experts, obviously.
Right. Right.
And really welcome public help and input and any
Right.
information that they have to be fed to the IEB.
Absolutely.
And the one other thing that I wanted to report to the commission is that we get questions every now and then about how are we going to evaluate the public outreach by applicants. And it's a statutory criteria, it's part of the evaluation criteria that their outreach to communities is part of our evaluation. It's included in our regulations and it's part of our evaluation. But it's something for us to consider as we, continue to move forward and refine how we look at our evaluations and how they're weighted and what importance do each of the proposals, each of the criteria have. Obviously, mitigation has been put out as a very important criteria for the commission to determine, but it's beyond just the surrounding community agreements or host community agreements. It's the outreach as well that's part of the statutory criteria.
Okay.
That's what I have to report.
Before you leave, we've decided to leave the schedule, the macro schedule in place for these things. Do we need, and they have deadlines for various events within that, do we need to set any other deadlines? Are there site identification deadlines that we need to set? Are there, identify all your qualifier deadlines that
Do you want to come back
we
and
need
join
to
us for this?
set? Or are we okay?
So the commission had asked Director Wells and myself to take a look at the four applicants and determine whether or not there should be a specific deadline for qualifiers. And we had conversation with each of the four Category 2 applicants to determine how they will be able to meet our schedule for qualification. And we did receive a proposal on how one of those four would be able to meet our qualification schedule, even in the absence of a defined site. So I'm going to let Director
Yes,
Wells.
so the proposer, we're still evaluating, we'd be working with legal. Generally, the setup would be that if this entity brought forth like a new qualifier based on the land deal, that if they did not, they would have the sort of contract in place, if you will, or the agreement in place, that if that person was found non-suitable by the commission, by the IEB, that would then trigger the default provision that the land would be sold. Now, there are still some provisions in there that I am looking at, and it's not necessarily a set deal. We've spoken with the consultants who have indicated to me that, yes, this could work. So you could move forward, it would not affect the timeline, and then ultimately, if someone's not suitable, they're out. So there's no concern that there's someone in the process. However, I've had conversation with Commissioner Cameron, we want to be careful as well that this is not someone working behind the scenes and still involved in the process and sort of skirting that issue. So, I'm not necessarily seeing that at this point, but I just want to make sure that we check every provision before we'd agree to it. But on its face, potentially that's a reasonable solution, and we're working with the applicant to see if that's fair and that would work.
And Director, we have the ability to, and it was clearly articulated, that anyone that we deem as a qualifier, just because the company didn't identify them, we may see some reason, a business relationship.
Yes.
And/or control, whether that be behind the scenes or
Mhm.
out front, we have the ability to say, you are a qualifier, submit your information. So I think we're covered along those lines as well.
But what are you,
No, go ahead.
well, we're talking about Cordish, which is the one that doesn't have a site identified
Yeah.
yet, it's not a secret. And it's probably Cordish that, because of being late to the game, that will not be done by the end of April, right? Will not have the background check done by
Correct.
the end of
I mean,
April.
that has not has to do necessarily with this issue, but yes.
Yeah,
because
but
some other
for
things, yes.
various
Right, various
corporate reasons
yes.
and whatever. And again, it's fine, I mean, there's no
Yeah.
negative involved with this.
Correct.
But you must be making an assumption on when you will be given this key qualifier in order to think that it will be able, you'll be able to be done within a couple of weeks into May.
Well, although
So-
if the nature of these organizations, my understanding is that, they can change how their business is structured as time goes on. So, for example, we've had a few qualifiers already drop out because they've resigned. They've had a couple of circumstances where we've had changes in the table of organizations, so they've had to
Vornado,
add
yeah.
yes, exactly. So this is a fluid analysis. So if, Cordish is telling us, you set a deadline, we will meet the deadlines. So if we have to, as this goes on, and, even through the phase two, if they make some changes to the organization, we may identify another qualifier. This is not a situation where, on a certain date, deal's done and nobody can change positions within the company, because it's the nature of companies, they're gonna change. So.
But this one's different. I mean, this, we know there is a missing
Yeah,
piece.
yeah.
Somebody's gonna own the land on which this
Yep.
thing is gonna sit, and we don't know whether they are yet
Correct.
who they
But that's
are.
the case with many of the applicants. They will not buy the land until they have the license.
But they're option.
They have an
land.
option.
Correct.
And
Correct.
we
Yeah.
have the right to determine whether we think the person whose land is optioned is a qualifier or not.
Yeah.
And now we don't know, it's at some point, what if it turns out to be that the person that owns the land for Cordish is a big international company, and we're trying to do a background check on them? It could take months, could slow the whole process down by who knows what. So it seems to me that, I'm just talking out loud
Yep.
here, I don't have my mind made up on this, but it does seem to me that in order for us to meet the deadlines that we've got
Yep.
here, we can make them having the final decision made on the fourth bidder early in May, okay, we're fine with that. But you need to have a date certain by which you will have their package done. That is, their full table of organization, all their qualifiers identified,
Yep.
in order that you'll be able to get your background investigations done by early May.
Yeah. And they've said if the commission wants to set a deadline such as that, then they will do it. So, and I'm happy to work however the commission would like on that issue. If the commission is not comfortable not knowing who that land, and I'm not sure, they haven't told me, so I don't know who potential additions may or may not be. I just don't know.
Well, why couldn't we set a deadline that was
Okay.
functionally related to what has to be done by when? And you're saying now that, as I understand you,
Yeah.
that we're talking about the second or third week of May, just because of things you know.
Right.
Is going to be when you'll finish with them. Why shouldn't we set a deadline that would enable you to finish by the second or third week of May, including the new information?
I'm comfortable with that.
If it's one single landowner, I mean, you can explore
Yep,
that with them. If
yep.
it's a single landowner, then you got one person to deal with. If
But
it's a
also they'll have-
multinational corporation,
Right, but even if it's a single landowner, as we've gone through, these
Yeah.
people, like Vornado, they had no idea what they're getting into.
Right.
They might say, whoa, I'm
Yeah.
not gonna do this, so.
Yeah, and I just don't know,
What was the assurance they made you that if there was a problem with the landowner, they would buy that person out immediately? What was-
I don't have the paperwork in front of me, but there was a trigger, so there would be a sale. Now, in their proposal, they had also, for example, they had talked about a potential long-term lease, and I had said, that I would not accept that because that keeps that person in the game, that potentially we'd have to put the sale. So there were certain provisions we're still looking at. So this is by no means agreed to, it's no means a done deal. This is just something they have brought to our attention for consideration, and we are in that process of looking at it.
but as I listen to this, it's not the outcome that's the problem. It's the
Right.
process of getting to the outcome.
Correct.
Mhm.
And if it takes you 3 months to get to there's a problem
Right.
piece, then we delay the whole category
Well,
2
although
by
I
3
think
months.
potential, and this is what I think their argument may be, and we still have to have some discussion on it, because this is, this is somewhat, brought to our attention recently, is that, I think their argument is so say there's this land piece, let's say there's an extra piece. If there's a problem, it should not necessarily so it's almost like a conditional approval, because if this person is found unsuitable, you could continue that investigation through the phase two. And if there's an issue where there's found non-suitable, they're out of the game because they're automatically bought out. I think that's their argument.
But they'd
is
have
that-
to have a host community agreement.
Well, see, that's-
Without
that's-
suitability being made.
Well, I think
in
it's
a
the
referendum.
conditional suitability that, so they've got the piece, and maybe the commission's not comfortable with that, and their argument to me right now, which we're flushing out, is that if that, if that entity, if there's a problem with that entity will be automatically removed.
Right, but I think that really misses the point that Judge McHugh made, and it's the way I feel too.
Yep, okay.
I mean, the more I talk about this, the more I think it's really important, because we know now from our own personal experience that these things can be very elongated, or people can say, we're not gonna do it. We've had both things happen. And if it's a local person who's never been through this before,
Yep.
and they don't have any idea what the background checks are gonna be, it's happened to us with a very sophisticated investor. What's it gonna be with an unsophisticated investor? So the more I think about it, the more I think we need to know pretty damn soon, because you're gonna need the time. There's no way to predict how long it will take to get the background done on this qualifier until we know who they are.
And I'm
We don't need to need the site.
okay.
We don't need to know the site. We need to know the qualifier.
And I'll check, I mean, and they may provide additional information to me based on this
So
conversation.
there's no
so-
time frame. They just
They
haven't
keep
been forthcoming?
not
Because
telling
I
me.
think it affects the next part of the schedule as well. How do you anticipate negotiating when those people don't even know they're under consideration?
Well, and that's where they're coming back saying, you know what, that's on us. If we don't meet the deadline, that's on us.
And I agree with
Is
that. I mean, that's their problem,
Is-
but our problem is background check.
Could we look at the schedule for a minute and, just to take the latest, is it fair to say that July 25th, as represented here, would be the very latest day by which, because that's, we have to determine the suitability then, at least as forecasted here. And take that date of 7/25 and back out
Oh, okay, seriously.
a number of days, an average number of days, your best guess as to what it would take for an individual or a corporation, and that's the deadline. Whether, whether that's, and that's,
You're focused on the wrong day. That assumes hearings and
well, I'm focusing on the latest possible day. We could, there could be an earliest. I mean, I guess the earliest is yesterday.
Yeah.
But I'm just for a matter of saying, well, what's the latest possible? I don't think there's any later than 7/25. That's where I'm coming from.
to be determined
To be determined
suitable
suitable.
after hearings and
Yes.
everything.
Right.
Yeah, okay.
In other words, everything that Director Wells is saying relative to automatic triggers, to purchases, to outing, whatever, really, in my view, unless somebody has another argument, that latest day would be July 25th.
Okay.
Now, back out from that date, what's realistically taking you to determine suitability of an individual, a corporation,
Yeah.
or either. And that's our deadline. Which could then afford us the period of hearings and et cetera, et cetera.
But it's what Director Wells has said, May 15th, more or less, is when she expects to be able to have all the background checks done. That's the deadline, not 7/25. So she needs to back up from May 15 to say, in order that I can make a recommendation to the commission by middle of May, when do I need to know who this qualifier is? And I'm saying the more I think about it, the more I think it's right about now, because it's so totally unpredictable how long it's gonna take. It could take a week, it could take 6 months.
In other words, there could be a non-hidden qualifier in that organization who the IEB makes a negative determination about. They appeal, they need time to prepare the report, then they've got 30 days to appeal, so it really is by the 15th that.
Of May, right?
But May 15.
Yeah.
So, okay. or May
I mean, you're
29.
Using your I mean, your
Yeah.
functional analysis is right, but you've got all that time that you have to,
It's
that
without-
automatically comes out.
That's right, it's without our control. I mean, all those dates are locked in.
So then the latest would be perhaps May 29, at least that's represented here.
Yeah, but we've changed that based on what she said, mid.
And I, you know, I don't know that maybe they have something set up where they could just buy the land, there's no additional qualifiers, I don't know, and maybe that's why they're not worried about it, so,
Yeah.
you know, yeah, I'm a little in the dark.
So you probably need additional information from
Yeah,
this
to get,
applicant.
to get the timeframe, but if the commission wants any person that would be involved in the land deal or deemed a qualifier to that, have that be completed by this 15th and not have, because of the trigger provision,
Right.
allow it to go into phase 2, then we can call, you know, we can check in with them and set that deadline. I'm perfectly comfortable
I
with
think,
that.
I think that's what we're saying.
Okay,
Yeah.
absolutely.
May 15 then?
Yeah, as a practical, I mean,
Yeah.
May 15 is not an absolute, but her
Yeah,
best
I'm
judgment,
working on it.
her informed best judgment at this point was May 15th. And we don't, I mean, if you can't make May 15th and it's May 29th, fine, we'll live with that.
Okay.
But at the moment, she's targeting May 15th, so we don't want this one wild card to blow a schedule which everybody else could make.
Okay, certainly, yeah, we can do that.
Okay,
Great, thank you.
Thank you.
Thank you.
Thank you both.
thank you.
That's really helpful.
Mr.
Yeah.
Chairman, I'll need a break. if
Yeah,
that's
I'm
okay.
gonna make the same suggestion. Wow. It's, next up is racing. We've done the master schedule without formally getting to it. I think we did beat that one to death. So let's take a quick break and we'll come back and do racing division in a minute. Director Dernberger.
Good morning,
Good
Mr.
morning.
Chair and Commissioners.
Good morning.
I had to think for a minute. We come before you with a pretty good list of things to talk about today. I'm going to start with an administrative update, which will probably be one of the longer ones that I've presented to you. There's a lot going on right now in racing. First, we'd like to start off by reminding everybody that the Racing Division is requesting public comment on our latest round of proposed changes to 205 CMR 4 and 6. The proposed changes were adopted by the Commission on an emergency basis last week, and they can be found on our website. The deadline for public comment is Friday, April 19th, and a public hearing has been scheduled on the matter for Monday, April 22nd at 84 State Street, not in this building, but 84 State Street at 11 a.m. Live racing in the Commonwealth, we're excited to remind everybody that live racing season is rapidly approaching. Plain Ridge Race Course actually will be taking entries tomorrow for its first round of qualifying races to be held this Saturday. Additional qualifiers are tentatively scheduled for April 9th and 13th, so there'll be activity at the racetrack. Opening day for live racing is Monday, April 15th at 1 p.m. And the Suffolk Downs backstretch will open for training on Saturday, April 20th, so that's also just right around the corner. And we also welcome the thoroughbred horsemen back and welcome their participation in the 2013 season.
And everybody, all of our friends are invited to come to opening day on, or what do you call it?
Well, opening day,
Opening
or
day?
any day.
All right, or any day,
Or
but
any
starting
day.
April 15th, all of our friends are invited to come to the opening of Plain Ridge and later on Suffolk Downs.
June 2nd, right?
June 1.
June 1.
June 1 for Suffolk Downs, but Patriots Day, I guess, for Plain Ridge.
That is correct.
Right.
We have an update on the parimutuel auditing system that resulted from an RFP the Commission put out. This is the Paraglobal Group, otherwise known as CRIMS. We're in the implementation period as we speak of this, and we could be up and running as soon as April 19th, which is fantastic, I think. Full functionality is expected in mid-May, and we'll have representatives from the company on site mid-April to assist with setting up and training. The system will run in parallel with our existing system, of course, initially until such time as it's appropriate to discontinue.
Since our existing system is so good.
Our
Not really.
equine drug testing laboratory update. This is the racing medication testing program also resulting from an RFP that the Commission put out. Supplies have been shipped to Plain Ridge. We've had to order some additional equipment, some storage equipment, and other sampling items. Everything has been ordered. Everything looks like it's going to arrive on time, and we expect that program to be fully operational by the start of live racing.
It's great.
It is great. I like reporting good news.
Yeah, it's great.
I do have a racing personnel update matter. The live racing licensees submit to us lists of key operating officials and racing officials for approval for the live racing seasons, typically 30 days before the meet starts. We did have a racing hearing on March 20th, at which time Plainridge submitted that list to us. And they put forward, on Monday evening, after we had already posted the agenda, they put forward an additional name for approval. This is for the position of judge at Plainridge. The name is Anthony Salerno. And my recommendation would be to approve Mr. Salerno pending completion of a background check. That is typically how we handle the racing officials at the meeting on March 20th that we had the racing hearing. And so that would be my recommendation to you today, but I think that may have to be put in the form of a motion, so.
I don't know that it does.
Have we approved these people before?
So Commissioner Cameron, in her capacity as a hearing officer, presided over the list that came to us on March 20th. And so, Commissioner, do you wish to make any comment on that as you're drinking your tea?
So this is a timing issue.
It's a
Mr.
timing
Director.
issue.
So rather than wait for our next hearing, you're asking the full commission to take this matter up today?
Yes.
Because this is an addition to the group that was submitted to me. So I move that we conditionally approve this official, his name, Mr. Salerno, as we have done, as I have done with the other key employees, and that's pending a successful background investigation by the state police.
I'm happy to vote on this, but do we vote on employees? I don't remember that we've been voted on employees before. Do you?
Well, I have done it on behalf of the commission.
Right, but why don't you do it on behalf of the commission again?
Well, since the whole commission is here.
Oh, all right.
It probably makes more sense for all of us to move forward with this, and rather than wait, Mr. Chair, until next month's hearing, we want to move this along.
Fine.
Right,
Motion
Do
is
I have a second?
Second.
Any further discussion? All in favor?
Aye.
Nay, opposed? The ayes are with you all the way.
I think that concludes my administrative update. We will turn to the legislative review project, what should be the conclusion of that. This was, to remind everyone, in the session laws of 2011, the commission was mandated to review the parimutuel and simulcast laws for efficacy and need to change. We've come before you with a draft report to be filed with the legislature, as well as some recommended statutory language. We've come before the commission with that, and what we have today are some incorporated changes, some comments based on those comments received from the commission, I believe, 2 weeks ago at the meeting. So I'm going to let David take up this piece. Danielle is here with us as well.
Mr. Chairman, Commissioners. If I could just take up first on page 16 of the report, draft report that you have. What we have done is to put some flesh on the bones with respect to premiums, a little history of premiums, and some bit of policy analysis as to why it is we are recommending that premiums be abolished and in effect, as the legislature has done already in the Gaming Act, replace it with the money that's being put into the Racehorse Development Fund from gaming and from racing. Before I take up what's in the proposed new chapter, there are a couple of, well, there's one typo that we've caught thanks to Judge McHugh's eagle eye, and another which is a bit more of a substantial omission. So the first would appear on page 4, subsection C. At the end there, it says convicted of violating section 5. It should be section 5C, and we will make that change.
David, are you talking about the report or
No, the
proposed new
Commissioner,
No, I
the
thought this-
proposed new chapter. On page 4, subsection C, on that page towards the bottom. At the end, it says, been convicted of violating section C, it should be section 5, it should be section 5C. A more substantial omission is on page 25, again, of the proposed new chapter. And you will see that the last red line insertion says, and the simulcast licensee, that is not A. That's obviously garbled. What it should say is, and a simulcast licensee that is not a racing meeting licensee shall pay a substantially similar amount to be determined by the commission by rule or regulation into the Racehorse Development Fund. And what that is trying to do is to balance, as is made clearer over the page on that red-lined insertion, that we do not want to have race meeting licensees who are simulcasting at a disadvantage with respect to takeouts or compulsory payments from gross wagering amounts. We don't want them to have a different takeout structure than for the gaming licensee that is not a race meeting licensee, but is also simulcasting pursuant to a 7B license. So what we have tried to do is to mirror for 7B licensees the takeout structure and each individual item of takeout that is applicable to mirror these takeouts that are applicable to racing licensees to non-racing gaming 7B licensees.
I understand the intent, and this was the only question I had about this draft. What does substantially the same mean?
Well, that phrase,
I guess my question is better put, why isn't it possible to just set up a structure for both in terms of percentages that would yield that result, rather than leaving it to the regulators to create regulations that do?
well, that's because some of the takeout provisions don't require a fixed percentage. Like, for example, in section 7B, it says a minimum of 10% must be taken out. The commission could increase that amount to 12%, for example, and that would require adjustments with respect to perhaps other obligations, takeout obligations of a 7B licensee. So there is wriggle room, perhaps that's an unfortunate phrase, but there is some discretionary factor that's written into the simulcast provisions of the gaming statute. And there are also some discretionary factors that are in place now in chapters 128A and 128C. So in order to give authority to the commission to craft remedies, should someone come and say, we're being disadvantaged because of the takeout structure that's applicable to 7B licensees as opposed to racing meeting licensees, we've put in, Judge McHugh, this catch-all.
And we can do takeouts by regulation.
Well, I think that we can adjust takeouts if the principle that is directing the adjustment is in the statute.
Okay.
Anybody else?
I had a couple of questions. Perhaps we could go to the relevant sections for my edification. 128D8. Relative to the employment of veterinarians, Director Durenberg, you've expressed in the past that other jurisdictions, as a best practice, those veterinarians sometimes are employed by the commission
Correct.
directly. Is there language here that would allow us to do that in the near future, or does that matter?
It does, the language that's here, and actually this is existing language, but
Okay.
this language continues the ability of the commission to
Okay.
employ as many as it sees important. And
Excellent. On section 10, 128D10, wagering by minors only carries a penalty of $100. Is there any similarity or parallel on the Gaming Act relative to that? Or could this be, will this be superseded by regulation for the casino floor, for example?
I've not looked at the Gaming Act, Commissioner, to see whether there is some penalty, and what the size of the penalty is. We
Significantly more.
If it is the wish of the commission, obviously we can simply amend that to make it equivalent to whatever the penalty is
In the Gaming Act? Okay.
Are you suggesting we do that?
Yes.
Yeah, I mean, it
Yeah,
sort of seems-
under the same general principle of harmonizing that you've
Yep.
expressed in the past.
Yeah.
And that, which leads me to to my last point on 10A, which is also the exclusion of certain persons. We know I know there is a lot of language in the Gaming Act relative to exclusion of certain persons, and whether that also needs to be harmonized with racing operations, because it is conceivable that one of our operators may or may not get a license for gaming.
do we know if any of these numbers appear in a penal code anywhere in Massachusetts? Where do we have the ability to just change them here, or do we need to make sure that?
Well, we can always change them
Yeah.
here. I mean, it's the legislature that's going to be making the change. So this number, $100 in section 10,
Yep.
is what is currently in the
Right.
equivalent of
Right.
this section, currently in force. And since the legislature is going to be making any change, that if they do make a change, any change that we recommend,
Right.
they would clearly have the power to do that, notwithstanding any other statute.
Absolutely, and again, the theme of the last two comments is, from my perspective, in terms of harmonizing with the Gaming Act, because I think it's a worthy call, if relevant, or
And
appropriate.
is that, Commissioner, just harmonizing the penalty provisions of 10A or something more that you would wish?
Well, the penalty provisions is what caught my eye.
Right.
But if there's other areas, I defer to you.
Well, all right.
Well, you were saying the excluded persons list, you were.
Right, well, but the hook is the penalties.
Yeah. But if is there compatibility between the excluded person lists and this?
Yes, that's an
That would-
important point.
I mean, that's, the excluded persons list will be a big deal in the gaming side, and it probably ought to be mirrored in the racing side.
Well, and it touches on a very large issue, policy issue, which is the gaming establishment and the definitions of which part is gaming establishment, which part is racing establishment.
Or if it's standalone, if it doesn't have a gaming license, it's just a racetrack, still, we would want to harmonize the exclusion lists, I would think.
Would we? I mean, is that done elsewhere? What about the OTB sites?
We looked at that initially in the project and felt like we were getting ahead of ourselves on the scope because we were trying to restrict it to the
Right.
paramount. And then it seemed as though that opened up a project of some considerable sinkhole characteristics, in other words, taking us away from our focus here, because we had looked at what other states do that have racinos, and we looked at the, how they manage that, the gaming versus the racing. If someone is excluded in racing, are they also excluded from the casino or not? And so,
Would it be more appropriate to wait till licenses are issued, and if in fact that occurs, to take a look or this is really our one opportunity to make these changes?
both?
Well, one of the policy issues here is whether or not there is going to be any, for want of a better word, continuation or continuity with respect to how racing has been handled as an entity. Or does the commission see the racing component as simply being absorbed within, to take further the director's model here, just part of the racing establishment, the gaming establishment. So, and if the latter is the case, then Commissioner Zuniga's comment has even more force, because we would have to not only harmonize, penalties, but also the kinds of access restrictions that exist in the Gaming Act. And that's something that I would recommend the commission think about for a while. Because I think that certainly the Gaming Act has a much more rigorous, is a much more rigorous environment than has ever existed for racing. So I'm not sure that the commission should plunge into treating them exactly the same.
That strikes me as right.
I'm thinking the same thing.
I think we should take a look at it, and I think we shouldn't jump into it. I think we really
Yeah.
need to think it through.
It's too bad, because I think that there aren't gonna be a lot of times to amend this legislation, but I think that's right. It's probably just something to go into your tickler file when we all get breathing room, is to say, okay, now let's step back
No,
and
it's
take a look
there.
at where else does there need to be decisions made about the integration of these entities.
Yeah, it's definitely there.
Yeah, but it's a tickler file item, not today, I agree. Okay,
Fair enough.
but very good thoughts, thank you. Anything else?
I just wanted to report, we met with the Thoroughbred Horsemen's Group yesterday, the HBPA, New England HBPA, to address some concerns that they had in the report that was part of the packet when we brought this to you a couple of weeks ago. And so we discussed our thoughts, we listened to their thoughts. I think their concern vis-à-vis the premiums is that they are looking, as we are, at an uncertain landscape in terms of what kind of revenue we're looking at from commercial casinos, what are, decisions haven't been made, and as we've kind of discussed with you all along, we're kind of building some hypotheticals on hypotheticals, using the best information that we have. But I think their baseline fear is that if we make changes here and things aren't as rosy as we all hope that they will be, I think they're just concerned about what consequences they may have, these decisions may have. So it's a valid concern, and I understand where they're coming from, and I just thought that I would carry that water to this meeting. I don't know that any of the recommendations that are in here I would change at this point, because we're in the same position they are. We need to
Right.
put forward the best proposal that we think, based on the information that we all share, the best information that we have. But I did just want to let you know we met with them, and that is their concern, and that's the overarching principle behind that letter.
Having in mind that then may be a flashpoint when this gets to the legislature, and
Yeah.
that this thoughtfully drafted report is going to be read by a lot of people who do not have a lot of familiarity
Yep.
with racing.
Yes.
Would it be worthwhile to add on page 14, 15, somewhere in there, just a definition of what a premium is?
Okay.
It presupposes knowledge of what a premium is. And I'm not sure that everybody knows.
I think it's in here, but I think that it would do no harm, Judge, to repeat it.
So this, it will go when? The report to the legislature?
Well, it sounds like we have a few more changes to make, and they're probably significant enough that you would like to see them again before we send them out.
I'm not sure that we do.
No?
I'm not sure
Okay.
that we
No,
do.
no, I
Okay.
think we can,
This is in really good shape.
yeah.
Well, I'm delighted you think so.
Yeah.
Excellent job.
So these will both go together? This will go with the report?
Yes.
And
Yes.
we will carry the section, yeah, okay.
Yes.
And the chart that you've already seen that's going to be attached to the
Right.
report.
The comparison chart.
Yes.
Yep.
Right.
Right, okay. So, do we-
And just to make sure that I understand, we are going to make the changes to the $100 penalty, or not? Just leave it as it is for now?
I would say leave it as it is for the points that
Okay.
were agreed on. We look at it because it's part of a larger conversation about harmonizing and defining policy-wise the notion of racing floor versus gaming floor, et cetera.
Okay.
okay. So do we have a motion?
Sure. I move that we accept the report and proposed chapter as drafted with the small edits, and as suggested by this conversation, and then forward this report to the legislature as we were required to do.
Second?
Second.
Any further discussion? What is the process now? Does it just go straight to them once we approve it?
Yes.
Okay.
Yeah.
Any other discussion? All in favor of the motion? Aye.
Aye.
Opposed? Ayes have it unanimously.
Thank you.
I think tracking this with the legislature, the appropriate chiefs of staff need to know that it's coming. There are probably gonna be some briefing opportunities again, even though we've sort of briefed them once or twice, but as you're able, I think making sure that that it doesn't just go off into a black hole, but that the right committee chairs get this, that their staffs know about it, and that we're stay abreast of it, because we want to make sure that we're really ready to brief people and to defend these positions when they come up, either in informal conversation or hearings or whatever. So that's an important coordination, I think, and Janice can help on that with the key staff people.
Okay.
Great.
Because we have to have this to replace the existing legislation, which disappears in a year, right? A little over a year.
A year and a bit.
Right.
Yeah. Okay, next.
Thank you, good work.
Thank you.
Yeah,
Thank
great
you.
work.
Great work.
Yeah, great work.
I had let's see, next on the agenda was a discussion about potentially having a hearing officer for racing. And I think Catherine maybe wanted to join me for that, so I'll have you guys. General Counsel Blue, I think, brought this up either last week or 2 weeks ago, and discussed the time has perhaps come to appoint a hearing officer for the racing division. So we just went back and looked through the previous rulings from years past and the appeals to the commission from the initial administrative hearings that are heard at the track. In 2012, 29 such appeals were scheduled, so it is a fairly significant workload for someone. There's scheduling, there's time involved in preparation, there's time at the hearings, and then there's tentative decisions. So it is a fairly significant piece. Commissioner Cameron had been designated by the commission on June 12th of last year to act in that role as hearing officer. And so we just wanted to discuss with you if this is the appropriate time to reconsider that, creating an in-house administrative hearing function. Did you have any additional?
Looking at the number of hearings that we see in racing and then anticipating the kind of hearings we may have under the Gaming Act, it makes sense at this point to start that process and then create a hearing officer function where there's a presentation on behalf of the commission, a hearing officer that hears it, and then written decisions that get written by that officer. That way, it creates a good record if it's an appeal to the full commission, or if in fact it goes farther than the commission. So we think the timing in terms of workload would make sense to start now, and that would give us good practice as we get ready for the similar issues under the Gaming Act.
I think the Gaming Act piece is really important to consider, and the phase-in, the gradual phase-in is really important. We're gonna need this. We're gonna have 10,000 licensed people by the time we get revved up. The enforcement problems are gonna be there. The workload is gonna be significant. And this is unique enough an area that we don't wanna send it over to Dala. So beginning to structure this now, I think really is a good idea.
Yeah, the only two thoughts. The only one I might have a question about is this says hiring a part-time hearing officer, and I'm not sure, given how quickly we're gonna start needing, if we're gonna license the slots parlor by December, the next day, there's gonna start being a licensing and a hearing process probably from the gaming side. Now, I don't know whether it's the same people or not, but you might need somebody full-time rather than part-time is all I'm thinking, getting ready. But this is really, my second thought was really this is between you all and Executive Director Day at this point. I think we're starting to get out of this kind of decision-making, and we'll defer to you all and Director Day. When you guys think it's ready to go, I think you go for it.
I think we can look at the timing in terms of hiring, whether it's a part-time person or a full-time person. Some of the agencies that I've talked to that have similar structures have multiple part-time people. Some of them have full-time and part-time, a combination. So there's a lot of ways we can think it through and take a look at it.
Right. But that's really, we're out of that business now, pretty much. I'm happy to say.
Okay.
Great, thank you.
Thank you.
That leaves
Okay.
the first quarter review of the Division of Racing Activities.
These are in the packets, right, with the Prescott?
Yes, they are.
Okay.
So to give you an overview of what we've done and what this document shows, your authority, of course, you took over the regulatory responsibility of the old State Racing Commission on May 20th of last year, and had been working with Division of Professional Licensure under an ISA. And you had brought in a consultant group. Spectrum was part of it. Last Frontier with Annie Ullman was the racing piece of that, to come in and assess the state of the industry, of the racing industry in Massachusetts. And that report was put before you back in July. And
Could I interrupt you?
you certainly can.
I noticed this in in the report that you wrote. Did we ask her to assess the racing industry, or we asked her to assess the commission and its operations?
Both.
Did we? Okay,
Yeah, we
fine.
did.
All right, fine. Okay,
We
go
wanted
ahead.
to know the state of the industry.
Okay, fine.
So the report, when it was presented to you in July, had 5 key recommendations. And so I have reprinted those in this document, well, 1 through 5. And this really looked at the regulatory structure of the State Racing Commission, the regulations that were in place for the industry, medication and testing, and personnel. So I want to just give you the overview here that we're going to look at 2 pieces, the regulatory structure piece and then the operational piece that we've had since January 1st. So the 5 recommendations from that report, one was to adopt model rules from the Racing Commissioners International, model rules of racing. And then what I've done for you is I've outlined what the steps that the commission has taken and where they've succeeded so far. So the bulk of the RCI model rules as they pertain to veterinary practices and medication were adopted by the commission on an emergency basis. Some of the model rules for safety equipment and other things that protect racing's participants have been adopted on an emergency basis and are going through the regular rulemaking process as we speak. And that's where the request for public comment is on the website right now. We are reviewing the model rules pertaining to racing officials and duties of licensees. And we anticipate after the live racing season is done that we'll be revisiting that. We'll go through the regular rulemaking procedure for that, working with the legal department as well, to tighten up some of the language that appears as far as appeals and administrative hearings and things that appear in our regs as opposed to the Procedure Act. And I'd also like to add that we're also going to review the wagering and tote security protocols because I think that's an area too that we've identified as needing some assistance and some strengthening. So we'll be doing that this fall. And we've been participating in a regional consortium, a working group to attest the medication and testing uniformity issues. As you know, you passed a resolution to support those initiatives, and we've been working very closely with them. In terms of having accredited racing officials working for the commission, I'm proud to say that we've been able to recruit a steward who is, the stewards act as administrative heads at the racetrack, so they preside over the occupational licensees, they make fitness determinations on licensing, they do the initial hearings if there are any allegations of violations of administrative rules. So we've brought in a steward who is not only ROPE, and that stands for Racing Officials Accreditation Program. Not only ROPE accredited, but actually also one of their course instructors and a member of the National Stewards Advisory Council. So we've done very well there. Both of our commission judges are the equivalent of stewards at the harness tracks. They are currently applying for licensure with the USTA, and one of our commission judges has already registered for the next 60-hour accreditation course, which will be held this July. The consultants suggested strongly that we outsource the drug testing for the racehorses in the state of Massachusetts. We have executed a contract now with an equine drug testing laboratory this is an international standard here, the ISO 17025, that's an industry standard. And this laboratory also recently submitted an application to the Racing and Medication Testing Consortium's accreditation program, which is a very racetrack-specific accreditation program that's up and running. So they've submitted their application, and we'll be working on that accreditation piece as well. Recommendation for the licensing procedure to include fingerprinting. We do note that beginning in July 31st, 2014, our statute will mandate fingerprinting of applicants for occupational licenses. And we are working with Investigations and Enforcement Bureau. We'll be in compliance by that date. If we can get that going ahead of that time, we'll be happy to do so. A recommendation was made to establish random drug and alcohol testing of occupational licensees. And as the consultants noted, there was a case here in 1989 in Massachusetts enjoining regulations that authorize both random and reasonable suspicion-based drug testing. We note that Suffolk Downs has adopted its own testing program for jockeys in late 2012, and we have identified a model program that we would like to use as we work with the legal department to see if we can devise devise some sort of structure that would be in comport, that we could do. So we're reviewing our available options there, and we have found a nice model. Our hands are a little bit tied at the moment until we do some more research in that area. Second key recommendation from the consultant's report was to upgrade the audit and financial reporting system. We have, as I mentioned earlier, executed a contract with an automated parimutuel auditing services company. We're in the contract implementation phase right now. And the exciting thing about this is, one, that it's web-based. Two, that by being web-based and by being automated, we have eliminated redundancy issues and the opportunities for human error. And we think it's also going to provide greater transparency and data accessibility, so in real time. We can go in at any moment and see real-time data coming in from totes. And I believe they have additional add-ons where racetracks and, for example, horsemen's groups can also pay to purchase password-based things, and they can also go in at any time and access their data. This should be up and running really within the next 30 to 60 days, certainly. They gave us, the latest date they gave us was The third key recommendation was to update the licensing system and/or utilize technology to enhance and streamline information management. The Gaming Commission is one of a handful of state regulators working with Racing Commissioners International on a beta testing program of a web-based licensing system. And what this will do is it eliminates the opportunity for input error by having some smart keys, so that if people have names with apostrophes or suffixes, it will highlight that. Did you mean to put in, just as a double check? It's web-based, and so at any time we can respond to inquiries from other racing commissions looking for licensing data on applicants in their states. We do note that there's room for improvement of the security features that appear or currently don't appear on the individual badges issued by the commission. And we'll be working with the IEB and Division of Licensing as they get staffed up to talk about the security features.
Could this licensing software work for the gaming licensing as well, or is this specialized to racing?
I don't know well, at the moment it's specialized to racing, but it's interesting because some of the commissions that are part of the beta testing program do have racinos.
Gaming, yeah.
And it does have functions where you'll be able to click, you can enter in the amount of money that you've received from the occupational licensee as they're paying for their license, or fines, administrative fines, and you can print out receipts. And so it seems as though that could potentially be something that could be added on, but Racing Commissioners International does regulate racing.
Racing, yeah.
So-
Well, again, this is something that you, in collaboration with Executive Director Day, are going to take care of, but
Yeah.
there'd be wonderful if there were an efficiency between the two systems.
And if not, what this does is it's a great bridge,
Yeah.
because it's at no cost to us as part of the beta testing program and members of RCI. It can run in parallel with our existing system, but it's also an access database-based system, and so whatever decisions are made by the licensing department, should be able to seamlessly be updated and imported into that system. So
Great.
we thought this was a
That's
fantastic way
great.
to go.
Does it also allow us to look into the databases of other racing commissions and vice versa?
It does. So, and again, knowing that the database is only as good as the people that put data
Right.
in. So in other words, it's incumbent upon us to enter our rulings and to enter
Right.
our licensee information correctly. But once that's in there, yes, if an applicant is in Florida, it will pull up all the information, any rulings, if there are any dates of licensure, dates of fingerprinting. So many commissions will do the printing every 3 years, and it'll show the last date and where those prints were done, so that the background check can proceed in a faster, more efficient manner.
That's great.
Does this system, what's the name of this system, do you know?
I don't know if it has a
Okay.
working name.
Okay.
I can certainly find out for you.
No, I'll follow
But it's,
up on
yeah,
that.
offered by Racing Commissioners International. I believe there's 7 states that are part of this beta group.
Pennsylvania, one of them?
I don't know off the top of my head. It's been a while since I reviewed the
So
list.
a very comprehensive system there. It was brand new, a licensing system.
It may be, because they work closely with RCI, that group, so.
Yeah, but the fact that this is networked with all these different states is itself
This-
a terrific.
That's what
terrific
this one
advantage.
was, which
Yeah.
was
Yeah.
Right.
obviously very helpful.
Yep. And we do, Commissioner McHugh, we do have the ability right now when someone comes in to get licensed. They are licensed under the Massachusetts system, but RCI does offer a web-based lookup. So as part of the licensing process, our staff do enter that occupational licensee's name into the RCI database and pull up any administrative rulings.
Right.
So,
Great.
but this
Great.
is it's a patch between the two. Where were we? Recommendation number 4. Investing in human resources to enhance the professional profile of the State Racing Commission and the Racing Division of the Massachusetts Gaming Commission. We note that we've been able to recruit several individuals with broad industry experience at the national level. That would include your Director of Racing. We've also received, we've been able to hire a Chief Parimutuel Officer. Her start date has been delayed, but she is on her way. We have this Associate Commission Steward who has tremendous experience in the industry. We've also contracted with several key industry professionals to provide in-service training, conference calls, webinars, and other educational materials. And that's actually been a great thing to do because we've been able to get the best people in the field, on a once-off, like a 1 or 2 day basis, or even just a lengthy conference call. And that's been fantastic, and it's been a great exercise for me because it strengthens our connections to other commissions, other groups nationally, but then it also, I'm noticing enthusiasm among my colleagues as well for doing this. More people should do this. We should do things like this more often. So it's been a very nice industry dialogue. Excuse me. We do note that we had, when we posted for stewards and judges, we had interviewed several ROPE accredited and USTA licensed judges, but were unable to reach mutually agreeable pay rates. And racing operations in the past have always been revenue neutral, and we've really been trying to stick to that for a number of reasons. But we do anticipate that until the operating budget, if you will, of the racing division is increased by some of the changes that actually are in that report. Some of the recommendations we've made are to have some increased money coming into our budget to help defer the cost of regulation. Until those monies come in, that is a realistic ceiling on our ability to enhance the professional profile of the division.
This is part of why I made the point about talking about the legislature about this report, because there will be pushback, as you said,
Sure.
on various issues. But we have a tremendous interest in making sure we've got enough money to do the regulation right, and tying it into this is really important, that they understand. That's one of the reasons why we're doing this.
Can I pause for a minute here and just thank you. I think one of our best investments in human resources has been your hire.
No question.
I'm glad you mentioned it here, but I want to highlight it for the record and for everybody because not only for when it comes to racing, but really when it comes to the business of the commission. So I want to just express my thank you.
Thank you, Commissioner.
Yeah, I would thoroughly agree with that. This has been a sort of the improvements over the last year and the changes over the last year and the upgrading in the administration over the last year have been at your hands, Director Dernberger, just terrific, and they're enormously refreshing and bode well for the future of racing in Massachusetts. And it's been a real pleasure to watch this happen and to see you work your way through these difficult issues each time, making the organization better than it was. So, thank you.
Thank you, Commissioner.
I was going to wait until after recommendation 5, but as long as we do this, I'll just jump in. I think there are two things that are worth noting. One is Commissioner Cameron, when she took this over, got the idea of getting Annie Ullman as an objective assessment to come in and take a clean, fresh look at this, which is where these recommendations came from. That was a terrific idea. Annie was great. Her assessment was really good. And then Commissioner Cameron also discovered Director Durenberger, and we hired her. But, I mean, we've quietly remade this total commission structure in dramatic ways. As you are going to say, there's still issues to deal with, but
Sure.
But it's been quite a remarkable and quiet transition. And starting with you, Commissioner, and now with you, Director,
That's absolutely-
deserve a lot of credit
I
for
think we
this.
all collectively thought it was important to, okay, this is our first opportunity to regulate, let's do it very, very well, and that will be, we will follow by doing the same with gaming. So, and again, I want to, all the credit, I did a little recruiting, but Director Durenberger, frankly, is the subject matter expert here and really has taken on some very difficult issues.
I can see the press is now tweeting out, "Commission pats itself on the back." Big news, Commission pats itself on the back. But anyway, but thank you, it's great, it's really.
Somebody's gotta do it,
It's
right?
really important stuff. Yeah, right. Can't get-
Unanimously.
Right. You had a 5-0 vote.
5-0 vote.
The commission patted itself on the back, right.
No abstentions, right?
No abstentions, right. So, thank you and congratulations. Now, please proceed.
Thank you, Mr. Chair. Let's see, where were we? Key
5.
recommendation number 5, that the Gaming Commission should arrange for an independent audit of the racing division. And as it says, as noted earlier, this was just taken right out of the report. So as noted in the consultant's report, the Old State Racing Commission had not had the benefit of such an audit for several years. So you all, prior to my arrival, as part of your transition process, had contacted the State Auditor's Office to look at the period July 1, 2011 through May 20, 2012. And the results of the audit were issued December 31 of 2012 and were discussed here at the meeting on January 3rd of this year. It was a clean audit. The report concluded that the old commission adequately administered its operations and had adequate controls in place to safeguard assets, had adequate and complete accounting and contractual documentation, and complied with applicable laws, rules, and regulations for the areas tested. We note that we are going to be currently working with an outside independent auditor to schedule and conduct a number of periodic audits which appear in 128A and C. Some of them are mandated, others are authorized as the commission sees fit, and so we'll work on a schedule of those audits for you. And so that's the regulatory structure in a nutshell. I really think, the reason that the commission did this was, as it says in our mission statement on the website, on the Racing Division website, is to strengthen the regulatory structure in anticipation of the monies coming in from expanded gaming. I think what you've done is you've been proactive. There are other states that maybe were not in a position to be proactive and had to be a little bit more on the reactive side. And so I think taking advantage of this window of time and strengthening that structure before the money comes in from expanded gaming is really going to do the industry well in this state. So, so congratulations back to you all. That has been ongoing work really since you all took over in May of last year, getting that regulatory structure in place. The other piece of this, part 2, if you will, of the report, is the operational activities that we have taken over since the ISA expired on December 31st. So we've had our hands on these for 90 days. We've had, I'll go through this with you as well. There are some updates to the report that are here, some recent successes, and a couple of things that I also want to add. One is, as I said, we're going to be doing some significant look at wagering and security protocols over the summer and the fall. We're going to look at model rules. We're going to look at best practices in other jurisdictions. Commissioner Cameron and I are attending the Racing Commissioners International Annual Conference in April, later in April this month. And one of the big topics there is also going to be the wagering and integrity protocols. So we expect there's going to be some big changes for that coming down the road. Public records requests have been an issue. We do have a valid forwarding address from the Old State Racing Commission's address, but it does take a while for the mail to find us. And so we have been in receipt of some public records requests well after the 10 days that we had to respond had expired. So we're working on that now that we've been made aware of it. We're checking on a weekly basis the mailroom here. We've double-checked that the forwarding address, the forwarding order is in place. It is. But we have responded to all the requests that we know are out there. We've responded to all of them. And we've sent a letter of apology and explanation if that was appropriate.
Is there another set of issues which relate to the other stuff? In other words, are we having a hard time responding to public records requests because we can't get the date, because we can't get the data, or do we?
No, it's purely just getting the request
All
in
right,
our
fine.
hands. Yeah.
Okay.
And in fact, we still get quite a bit of mail addressed to 1 Ashburton, and so by the time that finds its way, it does
Addressed
keep.
to 1 Ashburton?
Yes.
That was how many years ago?
Right, no, I mean,
That was before it
in the
came to
20s,
BPL, yeah.
Right. Okay.
All of the requests that we know that we've received have been responded to. The 2011 annual report here reflects that we only were in possession of it in draft form. However, late yesterday afternoon, we did receive the final report from Mark Kometz, the director of DPL. We did get that, and so I think what I have to do, I have to double-check the procedures on it. Typically, the commission would need to approve it before it went up the chain, I think, but this was the 2011 report, calendar year report, which was issued in draft form, I believe, in July of last year. But I don't know that it's your I'm not sure, I need to look out to find what the
Read to
procedure
approve
is
it,
here.
yeah.
Because, so we're looking at that, we'll bring it before you next week, either way, and we'll just figure out what we need to do with that. But we've resolved that. And the
Who
20.
does it go to when it moves on beyond us, if we do anything to it at all? Does it go to the, do we know? Does it go to the legislature? Does it go
It
to-
used to.
Yeah.
It used to, but that section, and I
Okay.
have to go back and look at
Okay.
it, but I thought that section had been repealed, and it was not replaced in the Gaming Act.
Okay.
So we need to find that.
We can't verify the information.
Well,
correct?
that's what I need to find out,
So it would be
yeah.
difficult for us to approve it.
Exactly.
Right, right.
Exactly. But it may have been approved at some level before it went up the chain through the agencies, and so I
Right.
need to work on that piece,
Okay.
and I will I will report to you next week
Thank you.
on what happened to it after it left, after it left staff hands last year. Let's see, the next page, periodic audits. So as I mentioned briefly a few moments ago, our law, our parimutuel and simulcasting law, requires the commission to conduct a number of periodic audits and authorizes a number of others. We note that with the exception of one of the authorized audits, and that is the PERS review, which is an important audit, other than that, we don't believe that these audits have been conducted in recent years. So what we've done is we've compiled a list, a schedule, we've made a calendar of them, and we are working with an independent auditing group to begin work on those, to do some prioritization and some scheduling, and we'll be in compliance on that piece. We've had a lot of technology issues, and I think this may be what you were alluding to with the public records request. So we've had numerous network and software issues since the the electronic transfer of the files from DPL to MGC, which took place, it says January 1st. It was really, I think, about the middle of January before all of the file transfers were complete. The system, the financial reporting system that the commission was using and the licensing database that the commission was using are not fully functional yet at this point. We're working on that. We're working with the programmer of the software. We're working with folks in-house, our IT, as well as the A&F support that we had through that group. It's been challenging and frustrating for all of us. We've been unable to access some of the reports that we need, for example, for the 2012 annual report. We have pieces of information, but we've had difficulties assembling all of the things that we need to assemble. We are working with this auditing services company to help us with the financial reporting system, financial services reporting system. That's the existing software. So the new auditing services system provider is meant to take over that particular piece of software, as well as what we're working on with the licensing database. So we want to eliminate the need for the commission's continued reliance on these programs. We anticipate both of the new systems to be operating in parallel with existing systems within the next 30 to 60 days, and we're doing the best we can with what we've got right now.
Is this a technology issue or a personnel issue? This is an issue we talked about once before, right?
The latest, in my IT knowledge, I may understand racing. I don't understand IT issues. I wish I could be an expert in all areas. My goal is to be the Renaissance woman, but I fail miserably in the IT department. So I'm understanding now, I got an email yesterday saying that it has to do with processing speed now. Apparently, I'm seeing, and none of this is verifiable at the moment, but slowness of the computer network, slow processing issues have affected the ability of these systems to update from the tracks, and so we're looking at that. I just received this yesterday and haven't had a chance to respond to it.
That's a
so.
report on the old systems, or that's a report on the new systems?
This is a
The old.
report from the programmer who designed the
The old-
software programs for
the
the
old
old
system,
systems.
yeah,
Yeah. And it's been frustrating for him as well, no doubt, so. So this is a challenge that we've identified, and we're doing the best we can with it. And we've enlisted some outside help. We put out the RFPs. We're working with RCI on the licensing piece of it, but it's a work in progress at the moment. So, and
I want to emphasize something that I think is key that you mentioned, which is you're really taking important steps to replace it.
yes,
With the RFP that you did with Barry Global,
mm-hmm.
so that the new
Right.
season will be
Right.
in much better shape. There's still the look back. There's still the report of 2012. There and among other things, but I think that's very important to highlight.
No, yeah, that's fine.
Okay. And so, in a similar vein, some data issues that we're having. So I think we're taking proactive steps to ensure the integrity of all of our programs going forward. But I do have some concerns about the accuracy of some of the historical information that was collected, and I want to bring it to your attention and let you know what we're doing about it. In particular, the calculations the financial reporting system was meant to do. There are a number of statutory allocations where money, when takeout is withheld from wagers, where those monies go. There are a number of funds, statutory funds that are created. There are commissions that come to the commission. There's a number of distributions. The distributions depend on the place where the wager was placed. So if it was placed at Plainridge, one thing happens to it. If it was placed at Suffolk, if it was placed at Raynham, something else happens to it. It depends on where the race that the people are betting on is. So if it's from out of state, one thing happens. If it's in state, something else happens to it. If it's on a harness race, something different happens to it than what's on a thoroughbred. So it's a really complex web of distributions and allocations. And those changed, as we've talked about, with the perpetual sunsetting of the parimutuel and simulcast laws every 2 years. Those were subject to change. Then when you add the acts of 2008, which abolished live greyhound racing in the state, since that time, every year in the session laws has appeared some sort of amendment affecting the Racing Stabilization Fund, among other things. And so there have been a lot of changes. These change frequently. Some states, the takeout is the takeout, the allocations are the allocations, and they're maybe only revisited every 10 years. Here, that's not the case. So you've got a system where percentages changed with some regularity. And you had a commission that was operating for a period of time without an executive director or a CFO or a director of parimutuel operations. And where the twain shall meet is the question. And so I'm just concerned that some of those changes along the way got missed. So we're working with an independent auditing group that's going to try and help us with the look-back piece.
This is KPMG.
This is KPMG, yep. So they're going to help us with the look-back piece. They're going to help us make sure that as we implement the new system, that the new system is implemented and it reflects current law. And we need to make sure there's a number of funds that are affected here. If you go to the next page, the Racing Stabilization Fund is one of them. This is the fund that was set up to provide for the humane care, maintenance, and adoption of greyhound dogs and to assist efforts to secure alternative employment and retraining opportunities for workers displaced by the abolition of greyhound racing. We have 3 different groups of previous occupational licensees that continue to receive periodic checks. We've been making those payments, but we're calling them estimated payments at this point because for 2 reasons. Initially, it was because we couldn't access the data that we needed to make those payments in the financial reporting system. Now we can access it, but there's some question as to the percentage that's being allocated there. So we're looking at that. There are enumerated distributions in the live racing statute in Section 5, in the simulcast statute, Sections 4 through 6. This includes distributions to the Commonwealth, various capital and promotional trust funds, purse accounts, breeders' funds, Tufts Veterinary School. I mean, there's just a lot of places where this money goes. And I'm working very hard to try and make sure that the right people are getting it in the right amounts. So again, we've enlisted the outside help of KPMG. They're going to be working
do
with
this
us.
piece to help with this piece?
Yes, they
too?
are. Yep, yep. And it's a tangled web. We don't know the extent of it. I can't give you an order of magnitude. Maybe everything was fine. Maybe the changes were communicated to the software programmer in a timely manner, and that because you're also complicated by the effective dates of some of this legislation as well. So it's just a lot of moving pieces, so we really want to make sure that everything's being done appropriately. And
So there aren't adequate records that reflect changes, so that's why you're unsure
Yes.
if these amounts were paid, okay.
yeah. We've noted other things like, as I mentioned, what happens to the takeout from the wager depends a lot on many different factors. And we've noticed we have somebody new is out at the tracks doing some auditing work there. And by auditing there, I mean actually taking the tote settlement sheets and entering data into the computer. We noticed that there was a racetrack that had been programmed into the system as a thoroughbred track, and in fact it was a harness track. So where there's one, there may be more. Maybe it's only one. Maybe there's more. I don't know. But we do know that we are distributing money to all of the intended recipients. So in other words, if this group or Tufts Veterinary or the breeders are supposed to be getting money, they're getting money. So we have been making distributions there. We just need to ensure that they're the correct ones. And let's see here. I guess I'm going to conclude.
Let me just, before
Sure.
you finish on that, I just want to I want to emphasize that we will continue to make disbursements based on the formulas that we have.
Yes.
Meanwhile, we're running the racing division,
Yes.
and KPMG is called in to go back and do what is practically forensic accounting, go back and figure out, whether, how many of these are right or wrong. We will at some point figure that out. It's gonna be a while, because it's complicated.
Yeah.
And if there are mistakes, then we will sort it all out and try to correct it. As you didn't mention this, but the racing, or maybe you did, yeah, the Racing Stabilization Fund, we've had representatives from the former dog owners and kennel owners concerned about this. It's a legitimate concern on their part. We're working on it as fast as we can.
Yeah.
So we're gonna continue to make the distributions in as well-informed a way as we can, but understanding that in due time, we're gonna check out all these formulas, and if there are problems, we will correct it after the fact.
That's a great summary, Mr. Chair. And for the Racing Stabilization Fund, the estimated payments that we're making were based on those last payments that had been made through DPL. So that's, we're using that.
And KPMG has started, right? They're gonna do both the audits, which have never been done, hadn't been done for quite a while, and they're gonna do the backward look.
That's the plan.
To assess what the problem is here.
Yep, that's the plan.
Okay. Great.
I enjoyed your conclusion, so I may actually leave it at that. I just, again, I guess the big umbrella here is that we've got the two pieces, the regulatory structure, which you've had a little more time to work on, and the strides going from here to here. And the commission has now positioned itself to be right on track with the rest of the industry as it makes additional changes and amendments. I mean, these model rules change sometimes more than once a year, amendments and things like that to it. So we'll stay on top of that. So we'll be in lockstep with everybody else, which is just a huge piece. And then there's the operational aspect, which we've noted some deficiencies, and we are working, and this is our plan, and we are doing the best we can with it. And I think that reaching for the outside help is an excellent thing to do. They certainly know what they're doing, and we'll
Great.
work with them and get this thing sorted out sooner rather than later.
And it
Great.
turns out KPMG does have personnel who have racing experience, which is really
Terrific.
important, yeah.
Not only that, local personnel. as
Local
well.
personnel, yeah, which is great, because this is such an arcane area.
Specialized vocabulary.
Right.
Excellent. Great work, great
Yeah,
report.
great
And
report.
I could add, if I could add,
Yes.
in our initial conversation with KPMG, they were not surprised by this story. This is not the first state that's had to deal with this issue. And so they're familiar with the story and understand the reasons how these things occur, so.
Right, yeah, good point, thank you. Anything else?
I think that's plenty, Mr. Chair.
That was plenty, yeah. Nice.
Great job.
That was great.
Thank you.
Thank you.
Thank you.
Yeah. Okay, it is now almost 12:30. We have one topic left, the Region C conversation. I think we should take a lunch break. How long do you want to break? Is a half hour enough?
Yeah.
Okay, so we'll be back here, let's make it 1 o'clock, and pick it up with that topic as soon as we get back.
Yeah, thank you.
Thank you.
Thank you.